who break the law against people that we should protect.
Liz Saville-Roberts.
I spent yesterday on D and F wing in HMP Swansea, and what I was told time and again, also by the dedicated search team, that what the prison needed desperately was a body scanner to reduce the incidence of drugs arriving in the prison. Could he tell me what are his plans to roll out body scanners to the entire prison estate?
So body scanners can be very useful, particularly in local prisons where prisoners are coming in and out a great deal. They are very expensive bits of kit, not just to install, but also to man. And they also do have medical implications. They can be used safely perhaps 50 times in a year. So we're conducting a pilot with 14 of these X-ray scanners across the estate. Once we've looked at the evidence and convinced ourselves this is the best way of doing it, we will of course move forward and we will prioritise the local prisons in that rollout.
Davey.
Thank you, Mr. Speaker. Inexperienced prison officers, poor conditions and more time is being spent in the cells contribute towards violence in prisons. What steps have been taken to address these?
Well, in terms of inexperienced prison officers, it's about longer training courses and it's about better mentoring on the wings, making sure particularly the Band 4 officers are working there day in, day out with new staff. The question of time out of cell, the more staff that we have, and that's why having 4,700 more staff is really important, allows us to unlock people more and allows us to get back to the kind of regimes which allow people to get into education and work and protect the public.
Hussain.
Thank you, Mr. Speaker. The point the Minister conveniently misses is frontline prison officer resignations have more than tripled since 2010. And now 1 in every 3 officers have less than 2 years' experience as the Minister fails to get a grip on a retention crisis caused by years of relentless cuts. Does the Minister really think this exodus of experienced staff is how he will keep prisons safe as assaults and violence rise to record levels?
Well, there are two separate things here. Absolutely, the Shadow Minister is absolutely correct. Experienced staff are vital. But it's also worth bearing in mind that one of the reasons why there are so many new staff is because we've recruited 4,700 additional officers. So by definition, many of them will be new. However, this question about retention is vital, and in particular the development of the advanced prison officer grade, which allows experienced closed grade officers to move from Band 3 to Band 4, will be very important in terms of stabilising prisons.
Ian C. Lucas.
Well, Mr. Speaker. Transforming rehabilitation opened up probation to a diverse range of providers and extended support and supervision to an additional 40,000 offenders leaving prison. The MPS is performing well in supervising high-risk offenders, but we have been clear that the performance of CRCs needs to improve. That is why we've taken action to end contracts early and conducted a public consultation on proposals to better integrate probation services. We are reflecting on the feedback received and lessons learned from current contracts as we develop future arrangements, and we will announce our plans in detail later this year.
Ian C. Lucas.
Thank you, Mr. Speaker. My constituent Nicholas Churton was murdered by an offender who was on licence. Following his release from prison, an assessment was not carried out by the CRC, and the murderer committed 2 further offences before he went on to commit another offence which killed Mr. Churton. Now, all of this information is in the public domain because I have put it there, and I want to have an independent inquiry into this case so to inform the ministers, all of whom I respect, so that the probation service is functioning to prevent people suffering the way that my constituents' family have had to suffer because of the appalling system that we currently have in place.
Well, the Honourable Gentleman has raised a very important matter, and if I may express my sympathies to his constituents' family for what they have undergone. I know that the Honourable Gentleman has met my Honourable friend, the Prisons Minister, to discuss this. I think maybe meeting again on this point. Can I make this point? Is taken as a whole, these tragic cases are rare. Doesn't in any way undermine how tragic they are. but the fact is that because there is a greater workload, a greater number of people dealt with by the CRCs than was the case before, we have seen some increase in the numbers, but the rate falls below 0.5%.
Last week, the Prisons Minister offered to meet the family of Sam Cook, who was murdered by a convicted offender who was released on licence, just in a similar case to the one we've just heard from my honourable friend from Wrexham. They would very much like to meet him, and can he ask his officials to arrange that meeting as soon as possible? Mr. Speaker, they want to speak to the Minister to make sure that no one has to experience what Sam Cook experienced, and that the probation service is doing its job to protect the public from offenders who are released on licence and supervising them properly.
I know that the Prisons Minister would be very willing to have that meeting, but can I make the point, and this applies to both honourable members, we want to get this right. We do recognise that we need to reform the probation system. That's exactly what we intend to do.
Number 13, Mr. Speaker.
Minister Fraser.
Mr. Speaker, I'm very pleased to have an opportunity to highlight the important work that we're doing in the criminal justice system. Last year, we spent £882 million on criminal legal aid, and we invested this year, announced an investment of £23 million further for criminal advocates. We are spending £1 billion to transform our courts and tribunal service. But improvements to the criminal justice, as with the civil justice system, are not just about money. And we are seeking to bring our justice system up to date, modernising it, making sure people have swift and effective access to justice.
The Loughborough University report, Prized Out of Justice, identified how many people were excluded from justice because of the means test. Now, I welcome the review of the means test the government are conducting, but pending the outcome, would the Minister support calls from the Law Society for the means test threshold to be uprated now as part of the spring statement?
As the Honourable Member referred to, we have recently done a legal aid review. As part of that review, we were not obliged to look into thresholds because there weren't very many changes to thresholds as part of LASPO. But we recognise the need to look at that because figures have not been uprated for some time. We are undertaking that review, and the timetable for that is set out in our legal action support plan.
Thank you, Speaker. A recent report from Women's Aid has set out that many women are now having to represent themselves because they don't meet the threshold for legal aid. But the report also says that the women the only savings they have can only be used, so they have to be able to rehouse themselves. So can the Minister give some assurance that she's willing to look at improving the situation that these individuals are having, so they don't have to represent themselves in court, and which they can have a hugely negative impact on the victim's experience within the justice system?
I'm fully aware of the issues that these women face. I'm very pleased to have held a number of roundtables as part of our understanding for the review with a number of vulnerable parties, including women, and Women's Aid were part of those roundtables where we had an opportunity to hear from them directly. That's one of the reasons why we have specifically mentioned victims of domestic violence when we will look at the thresholds in the legal aid review that we are conducting.
David Morris.
Number 14, Mr. Speaker.
We're doing everything that we can, Mr. Speaker, to protect prison officers. That's both perimeter security to make it more difficult to get the drugs and weapons into the prisons. It's making sure prison officers have the protective equipment to protect themselves against attack. It's gathering the forensic evidence when an attack takes place. It's prosecuting prisoners who attack prison officers. We have a huge duty, and we will do everything we can to protect them.
David Morris.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to thank my honourable friend for that good answer. I would just like to say that the hard-working staff at HMP Lancaster Farms are doing a very good job in this respect, and I would like to invite my honourable friend to come to the farms whenever he can do. Thank you.
Well, thank you. Lancaster Farms Catsea Training Prison, it's a challenging prison, and we are very pleased with the recent inspection report that we've received from Peter Clark. He's a tough critic, but he sees it as a decent and competent prison, and I'd like to take this opportunity to pay tribute to the Governor, Derek Harrison, for the work that he does.
Cummins.
Thank you, Mr. Speaker. Question number 15, please.
Mr. Fraser.
Mr. Speaker, the Honourable Member raises a very important and sensitive issue, but I'd like to reassure the Honourable Member that our family law system is centred around the child and the welfare of the child, and when judges make decisions about contact or care, the welfare of the child is always paramount. But we have been looking at various ways to strengthen our procedures and practice directions in relation to who gets notice of particular court applications. But I would like to remind her that the central principle is a very important one.
Thank you, Mr. Speaker. Following the recent high-profile case in Rotherham, has her department carried out a review into what went wrong, and can she tell us whether she's considering a change in the law to ensure that it cannot happen again, and if not, why not?
Well, I'm aware of the case that the Honourable Member is referring to. Very pleased some time ago to have met Sammy Woodhouse along with other Members of Parliament to discuss this issue. This is an issue which we are continuing to look at, the principles that underline it, and as I mentioned specifically also the practice directions and procedures around these sorts of cases.
Thelma Walker.
Number 16, Mr. Speaker.
Minister Fraser.
I'd like to assure the Honourable Member that any decision to close the court is not taken lightly. But in circumstances where 41% of our courts operated in 2016 to 17 at half their available capacity, and in circumstances where we're investing £1 billion in courts and bringing them up to date, in the Ministry of Justice we have to think carefully about where our court resources are most effectively and efficiently spent.
Walker.
I thank the Minister for her response. However, the recent closure of courts within West Yorkshire is putting additional pressure on those remaining, causing backlog and delays. The Hands Off HRI campaign, who are fighting to save our local hospital services, are waiting for a consent order, which is with Leeds Crown Court. However, the backlog of several weeks means that the campaign is undergoing a lengthy period of uncertainty, as are many other cases. What is the Secretary of State doing to ensure that cuts to staffing and closures aren't damaging to my constituents' access to justice?
Well, as I mentioned, when we undertake court closures, which are undertaken very carefully, and the Lord Chancellor does not take those decisions lightly, we do look at court utilisation rates, and the courts that are closed are often those who are not performing in terms of capacity. In terms of the particular case that she refers to, I'm very happy to take that up with her and look at any particular backlog and delay on a particular case.
Yasmin Qureshi.
Thank you, Mr. Speaker. The government has been forced to announce a one-year delay to their £1 billion court reform programmes. Many people are concerned that this reform programme is simply a smokescreen for sacking staff and closing courts. Will the government take this opportunity to have a public debate about this and allow for this Parliament to debate and scrutinise these changes?
Mr. Speaker, our court reform programme is one of the most ambitious in the world. We recently held a seminar with, where at least 20 other countries were represented, talking about their reform programmes, and none of them were as ambitious as ours in terms of streamlining, making more effective and modernising our court process. The delay in terms of the programme is to ensure that we can efficiently and effectively manage the programme going forward.
17, Mr. Speaker.
Mr. Speaker, we need to prevent these mobile phones from getting into prison. That isn't always easy because some of the new phones are almost just an inch in size. So that involves not just metal detectors, that involves also X-ray scanners that can look inside bodies. If they get inside the prisons, we need to identify them, we need to intercept the calls, and we need to block them and seize the phones.
Minister, for that reply, does he agree that where prisoners use mobile phones to send vile messages to the families of their victims, that social media giants like Snapchat must take responsibility and help the police bring culprits to justice?
Well, first of all, using a mobile phone in a prison is an illegal act. It's a horrifying thing to harass victims using a phone from prison. It's entirely illegal, and we will be working with colleagues in DCMS to draw the attention of these social media companies to the fact that illegal action is taking place through their systems.
Mac.
Thank you, Mr. Speaker. Question 18.
Technology can play an important role in supporting rehabilitation, and careful use of basic computers and telephones can enable us to do that. New digital services are being built for prison officers as part of the Offender Management in Custody programme.
Thank you, Mr. Speaker. Good mental health and well-being are key to rehabilitation in prisons. What steps is my right honourable friend taking to use best technology in this regard?
My honourable friend raises a very important point, and I think there's huge potential in this area, but we're already taking steps through telehealth, through virtual consultations. We've got Intel telephony, which can be used in these circumstances. Also, digital hub service exists, and the prison virtual learning environment includes some health applications. So we've got a virtual campus which can help people addressing addiction issues, but I think there is much more potential in this area in future.
Night. Question number 19, Mr. Speaker.
Mr. Speaker, with your permission, I'd like to group questions 19, 20 and 23. Under this government, the most serious offenders are more likely to go to prison and for longer, helping protect the public and keep communities safe. Prison will be the right place for some offenders, but equally there's evidence it does not work in terms of rehabilitating others. I want to move the debate on from the old false choice between soft justice versus hard justice, and instead make sure we're focused on delivering smart justice. We need to think more imaginatively about different and more modern forms of punishment in the community.
Thank you, Mr. Speaker. I support the broad thrust of ensuring sentences work, particularly for female offenders. But does the Secretary of State agree with me that at the same time we should look at early release and whether it could be recalibrated to improve prison discipline?
Well, what I'd say to my honourable friend is I do think that incentives within the prison system are important to achieve good behaviour, but early release does help offenders to successfully make the transition from custody to living crime-free lives in the community. An additional early release scheme for certain offenders, home detention curfew, further helps to manage this transition and reduce future offending.
Question number 20, please, Mr. Speaker.
The gentleman's question has been grouped. His opportunity is here. His moment is now. Let's hear the sonorous tones of the honourable gentleman.
I'm very grateful, Mr. Speaker. I understand the UK Government is looking at the effectiveness of short-term custodial sentences to reduce reoffending. I would invite ministers to look at the experience in Scotland, where short-term sentences have already been abolished, and yet reoffending rates remain stubbornly high. I would therefore urge ministers to look more closely at whether rehabilitation programmes in prison are working effectively, even those for prisoners on short-term sentences.
Well, I think what I'd say is that in conjunction with reforming short sentences, it is important that we have confidence in the delivery of community orders. We've been clear that in England and Wales probation services need to improve, and we have already discussed that, but I think the two have to run together: reform of short sentences and adequate community alternatives.
Thank you, Mr. Speaker. What is the government doing to ensure tougher sentences for those who are found guilty of violent crimes?
Well, under this government, and in the last 9 years, sentences for violent crime have gone up, and if we were to look at knife crime in particular, the chances of a custodial sentence have increased, and the length of the custodial sentence has increased.
Paul. Well, Mr. Speaker.
Thank you, Mr. Speaker. In the Female Offender Strategy, which we published last summer, we set out a raft of specific commitments underpinned by our vision to see fewer women coming into the criminal justice system, a greater proportion managed successfully in the community, and better conditions for those in custody.
Exactly. Luke Hall. Thank you, Mr. Speaker. Rates of suicide in female institutions are often disproportionately high. Can the Minister update the House on what he is doing to work with female prisoners to bring suicide rates down, including prisons like Eastwood Park in my constituency?
Thank you. Mr. Speaker, every death in prison is a tragedy, and we are committed to improving the safety and support available to all in our prisons. While the rate of self-inflicted deaths in women's prisons is lower than that seen in the male estate, we recognise the rate of self-harm is nearly 5 times the rate in the male estate. Therefore, we know we need to do more. That is why we have set up a specialist safer custody team dedicated to the women's estate and are rolling out revised and improved suicide and self-harm prevention training.
Order. Topical questions. Nigel Huddleston.
Topical number 1, Mr. Speaker.
Mr. Speaker, yesterday the Government was pleased to give its support and time to the Children Act 1989 Amendment Female Genital Mutilation Bill, sponsored in this House by my honourable friend the member for Richmond Park. The bill, which seeks to make a small yet important change to the Children Act 1989, offers both a simplification to the court process that is sensible and a useful extension to the family court's powers to protect girls at risk of FGM. It will add to the measures this Government has brought forward in tackling FGM issues.
Suffice, I think. Nigel Huddleston.
Can my right honourable friend provide an update on the Government's consideration of giving children the right to have access to their grandparents in the event of family breakdown or divorce?
I paid tribute to my honourable friend's activities in this area. I'm reviewing the options for strengthening the involvement in grandparents' and children's lives to explore in a future consultation. I will make an announcement of the Government's plans in due course.
Speaker, too many young lives are being lost to violent crime on our streets. Whatever the Prime Minister may say, substantial reductions in police numbers leaves our communities less safe. So does shutting hundreds of youth centres, and so too does the Ministry of Justice's halving of funds for youth offending teams since 2010. Tens of millions of pounds that once went to protecting children and their communities have needlessly been taken away. So when will this Government stop trying to do justice on the cheap and instead properly fund youth offending teams?
You say?
I don't accept the criticism that the honourable gentleman makes. This Government has announced a £200 million youth endowment fund. We are taking measures to deal with the sources of problems with this, and will continue to do that.
Thank you, Mr. Speaker. Can the Minister confirm that he's working with his colleagues in DEFRA on introducing the necessary legislation needed to increase the maximum penalty for animal cruelty from 6 months imprisonment to 5 years?
Thank you, Mr. Speaker. I absolutely confirm Britain has a very, very proud national tradition in campaigning nationally and internationally against animal cruelty. The Government remains committed to increasing the maximum sentence for animal cruelty to 5 years.
Lloyd. Thank you, Mr. Speaker. Means-tested criminal legal aid can only be granted where there is a realistic prospect of custody. Consequently, has a detailed impact assessment been undertaken to show how many people will no longer qualify for legal aid in the event of the reduction or abolition of prison sentences of 6 months or less?
Well, as the honourable member will know, thresholds across the board, including in relation to criminal legal aid, is part of our legal aid review, which we are now undertaking.
Speaker, some of my constituents have told me they've waited over a year for a court date to appeal a welfare decision. Can my right honourable friend assure me he's taking steps to improve access to justice for benefits claimants?
The honourable member is right to highlight that we need to speed up the time for people hearing and the hearing times for their welfare claims. There are two aspects to this. The first one is we need to work with DWP, which we are doing and I am doing with my counterparts in DWP to get decisions right first time. The second is to speed up those hearings.
Well, the Business Minister and the Secretary of State have heaped praise on the Durham Tees Valley CRC when I've asked about the not-for-profit organisation's future. But can he tell me, please, if it will survive the next round of reforms or be swallowed up and privatised with the rest of them?
Well, as the honourable member says, it is a fantastic organisation. We are, of course, conducting a very detailed consultation on the future of probation. But to reassure the honourable member, the principles behind the Durham's TRC, in particular the involvement of local authorities, the involvement of the voluntary sector and the close coordination with the MPS is fundamental to our reforms.
This is opposition to short prison sentences. It must follow that he is equally opposed to fixed-term recalls of 28 days when criminals reoffend when out of prison on licence or break their licence conditions. Will he therefore pledge to scrap these fixed-term recalls and ensure any such offenders are returned to prison for the remainder of their original prison sentence, as was the case in the past?
Where an offender is assessed as presenting a risk of serious harm, then they will receive a standard recall and may only be re-released into the community if they can be safely managed there. If there isn't that risk, then a proportionate response, I think, is sensible. Her Majesty's Inspector of Probation Services has found that probation services, in the vast majority of cases, are making the right decisions.
What discussions is the Minister having with his colleagues in the Department for Work and Pensions about the appalling tribunal backlog they're creating by poor assessment and decision making, particularly in PIP, Universal Credit and Employment Support Allowance?
I have had a number of meetings with my counterpart in DWP. My officials discuss this issue with them regularly. Me and my counterpart in DWP are going to undertake a joint meeting to an assessment centre to further consider these important issues, but to ensure that we get decisions right first time.
9,090 foreign national offenders in our prisons, including 760 from Albania. Why aren't these people serving their sentence in prison in their own country?
Well, this is a very good challenge, specifically on the issue of Albania raised by the Honourable Member. We have a prison transfer agreement in place. I met the Albanian Minister of Justice 2 weeks ago. We need to ensure that more returns take place, but we are well ahead of Italy and Greece in returns to Albania.
Justice funding has fallen from 145 million to 71 million in the last 10 years. Yesterday, the Local Government Association said no more. Are they right?
My department will continue to argue the case that we spend our money sensibly and get the best deal for justice.
James Carledge. Thank you, Mr. Speaker. Can my honourable friend outline what plans he has to increase support for rape crisis centres?
Thank you, Mr. Speaker. May I pay tribute to Fern Champion, who has been incredibly courageous in speaking out recently about this issue. It is an issue of huge importance, and we provide funding for 89 rape support centres, and from April of this year we will be increasing funding by 10% for all of them, 30% increase in London, and moving to a 3-year funding settlement.
Thank you, Mr. Speaker. My constituent Phil suffered from addiction, became homeless and then involved in criminal activity. Because he was given a suspended sentence, he was released from court with no money, no support and nowhere to live, and he spent the night on the streets. If he had been released from serving a sentence, there would have been support in place. Does the government have a plan to address this disparity to give people like Phil the best possible chance at rehabilitation?
It's absolutely true that we need to look not just at convicted prisoners, but also people with suspended sentences. That is something we're looking at the reform in probation, and it's also what the pilots on homelessness will seek to address.
Ruth George.
Thank you very much. Derbyshire Law Centre is the only place that I can refer many of my constituents in desperate need of legal support. Will the Minister commit to securing Treasury funding to provide a central grant to law centres to help ensure their survival?
Law centres provide an absolutely fundamental role. I recently visited Bromley by Bow Centre, or also Islington Law Centre. As part of our pilots, law centres will be able to bid for new ways of interacting with their clients, and I hope that they will take that opportunity.
Order. Statement, the Attorney General. Mr. Jeffrey.
Mr. Speaker, with permission, I would like to make a statement about my legal opinion on the joint instrument and unilateral declaration concerning the withdrawal agreement published last night. Last week, I confirmed I would publish my legal opinion on any document that is produced and negotiated with the Union. This has now been laid before the House. This statement summarises the instruments and my opinion of their legal effect. Mr. Speaker, last night in Strasbourg, the Prime Minister secured legally binding changes that strengthen and improve the withdrawal agreement and the political declaration. The government laid 3 new documents reflecting these changes in the House. First, a joint legally binding instrument on the withdrawal agreement and the protocol on Northern Ireland. Second, a unilateral declaration by the United Kingdom in relation to the operation of the Northern Ireland Protocol. And third, a joint statement to supplement the political declaration. Mr. Speaker, the legal opinion I have provided to the House today focuses on the first 2 of these documents, which relate to the functioning of the backstop and the efforts of the parties which will be required to supersede it. Mr. Speaker, let me say frankly what, in my opinion, these documents do not do. They are not about a situation where, despite the parties properly fulfilling the duties of good faith and best endeavours, they cannot reach an agreement on a future relationship. Such an event, in my opinion, is highly unlikely to occur, and it is both in the interests of the UK and the EU to agree a future relationship as quickly as possible. Were such a situation to occur, however, let me make it clear. The legal risk, as I set it out in my letter of the 13th of November, remains unchanged. The question for the House is whether, in the light of these improvements, as a political judgment, the House should now enter into those arrangements. Let me move on to what these documents do achieve. As I set out in my opinion, the joint instrument puts the commitments in the letter from Presidents Tusk and Juncker of the 14th of January 2019 into legally binding form and provides, in addition, useful clarifications, amplifications of existing obligations, and some new obligations. The joint instrument confirms that the European Union cannot pursue an objective of trying to trap the UK in the backstop indefinitely. The instrument makes explicit that this would constitute bad faith, which would be the basis of a formal dispute before an arbitration tribunal. This means ultimately that the protocol could be suspended if the European Union continued to breach its obligations. The joint instrument also reflects the United Kingdom and the Union's commitment to work to replace the backstop with alternative arrangements by December 2020, including as set out in the withdrawal agreement. These commitments include establishing, and I quote, immediately following the ratification of the withdrawal agreement, a negotiating track for replacing the customs and regulatory alignment in goods elements of the protocol with alternative arrangements. If an agreement has not been concluded within 1 year of the United Kingdom's withdrawal, efforts must be redoubled. In my view, Mr. Speaker, as a matter of law, the provisions relating to the timing of the efforts to be made in resolving withdrawal agreements makes time of the essence in negotiating a subsequent agreement. A doctrine with which the lawyers in this House will be familiar is of legal relevance. In my view, the provisions of the joint instrument extend beyond mere interpretation of the withdrawal agreement and represent materially new legal obligations and commitments which enhance its existing terms. Turning, Mr. Speaker, to the unilateral declaration, it records the United Kingdom's position that if it were not possible to conclude a subsequent agreement to replace the protocol because of a breach by the Union of its duty of good faith, it would be entitled to take measures to disapply the provisions of the protocol in accordance with the withdrawal agreement's dispute resolution procedures and Article 20, to which I have referred. There is no doubt, in my view, that the clarifications and amplified obligations contained in the joint statement and the unilateral declaration provide a substantive and binding reinforcement of the legal rights available to the United Kingdom in the event that the Union were to fail in its duties of good faith and best endeavours. Mr. Speaker, I have in this statement and in the letter I have published today set out frankly and candidly my view of the legal effect of the new instruments the government has agreed with the Union. However, the matters of law affecting withdrawal can only inform what is essentially a political decision that each of us must make. This is a question, Mr. Speaker, not of the lawfulness of the government's action, but of the prudence, as a matter of policy and political judgment, of entering into an international agreement on the terms proposed.
Nick Thomas Simmons.
Mr. Speaker, I'm grateful to the Attorney-General for his statement and for the advanced sight of it. Now, the Attorney-General made clear in his original advice of the 13th of November on the backstop protocol that in international law the protocol would endure indefinitely until a superseding agreement took its place in whole or in part. And he was right, because Article 178 of the withdrawal agreement is clear that the remedy of suspension of obligations is only ever meant to be temporary to secure compliance to the agreement and not as a gateway to a full exit. So people quite rightly ask now, Mr. Speaker, what has changed? In her Strasbourg statement, the Prime Minister said the joint interpretive instrument makes 3 changes. She said, firstly, the UK can challenge the EU in an arbitration panel if the EU is found in breach of good faith and suspend the backstop. But that was already in Article 178 of the withdrawal agreement. It is not new. The Prime Minister said there is a legal commitment that whatever replaces the backstop does not need to replicate it. But the January letter of Presidents Tusk and Juncker said any arrangements which supersede the protocol are not required to replicate its provisions in any respect. It is not new. Third, the Prime Minister said it entrenches in legally binding form the commitments made in the exchange of letters with Presidents Tusk and Juncker in January. But on the 14th of January, the Prime Minister told this House, "My right honourable and learned friend, the Attorney-General, has also written to me today confirming that in the light of the joint response from the Presidents of the European Council and Commission, these conclusions would have legal force in international law." That is not new either. Now, I'm going to take the Attorney-General at his word, because he said in his Mail on Sunday interview, and I quote, "I will not change my opinion unless I'm sure there is no legal risk of us being indefinitely detained in the backstop." I'm going to be fair to the Attorney-General. He hasn't changed his opinion. And let us read his advice to this House at paragraph 19. "The legal risk remains unchanged. That if through no demonstrable failure of either party, but simply because of intractable differences, that situation does arise, the United Kingdom would have, at least while the fundamental circumstances remain the same, no internationally lawful means of exiting the protocol's arrangement save by agreement." And I do say to the Attorney-General, paragraphs 15 to 19 of his advice constitute 7 sentences that destroy the government's strategy of recent weeks, that sink the government's case, that it had any chance of securing a right under international law to unilaterally exit the protocol's arrangements. We've gone, Mr. Speaker, from having a nothing has changed Prime Minister to having a nothing has changed Attorney-General. And, Mr. Speaker, in fairness to him, it isn't just his view. It's the view of a number of other respected lawyers, including Professor Philippe Sands, Professor Sir Edward David, and the government's own former counter-terror watchdog, now Lord Anderson QC. Because the Attorney-General knows that speaking about reasonable endeavours and bad faith is one thing. But he can confirm the reality, which is that the new documents do nothing about the situation when the talks with the EU are at a stalemate, not because of bad faith, but simply because both sides can't reach an agreement. Proving bad faith is extraordinarily difficult, and the Attorney-General points that out in paragraph 16 of his own advice. The strongest remedy in this withdrawal agreement, even with this document, remains a temporary suspension. And indeed, look at his own legal advice to see that at paragraph 9. That speaks of suspension of all or parts of the protocol, including the backstop, until there is satisfactory compliance. Mr. Speaker, trade talks can break down for a variety of reasons. For two parties to act on the basis of their own interests is not bad faith, and the Attorney-General knows it. In these circumstances, despite any assurances about the temporary nature of the backstop, the reality is that it can endure indefinitely. 92 days after the Prime Minister abandoned the first meaningful vote, in this Attorney General's view, the legal risk remains unchanged. Mr. Speaker, what the Attorney General was asked to do and what the Prime Minister promised in this House on the 29th of January to change the text of the withdrawal agreement simply isn't possible. He's a lawyer, he isn't a magician. Doesn't this whole episode of recent weeks show that when national leadership is required, this Prime Minister, as always, puts party before country?
The Attorney General.
Mr. Speaker, the honourable gentleman asks me about my opinion. Well, he knows that my opinion is that there is no ultimate unilateral right out of this arrangement. The risk of that continues. But the question is whether it is a likelihood politically. I have to say, Mr. Speaker, that one thing we didn't hear from the honourable gentleman is what the Labour Party's position was on the backstop. Do they accept the backstop? Do they think it's a good thing? And if they think it's a good thing, why on earth are they criticising it? Or is it just the usual political opportunism that one expects to hear from the front bench of the Labour Party? And let me say to the honourable gentleman, he says to me there's nothing new in this agreement. That is not so. And some of the authorities that he has quoted are saying it this morning. There are material new obligations. For example, in relation to alternative arrangements, there is a heavy emphasis now upon a swift and expedited track to negotiate them, and it would be unconscionable if, having made that emphasis, having said that time was of the essence, the European Union simply refused to consider or adopt reasonable proposals relating to alternative arrangements. That is new. What this document does is address the risk that we could be kept in the backstop by the bad faith and deliberate manipulation of the Union. And what this does is make significant reductions in that risk, Mr. Speaker. So I say to the honourable gentleman, it would be a good thing if we could hear from the Labour Party just occasionally, more than just political shenanigans, but some sincere engagement with the real issues that this withdrawal agreement now raises. The question now, Mr. Speaker, is do we assume our responsibilities as a House and allow not only this country, yearning as it is, for us to move on, but the entire continent of Europe? And to do that, Mr. Speaker, the time has come now to vote for this deal.
Mr. Ian Duncan-Smith.
Mr. Speaker, can I first of all welcome my right honourable learned friend to his place. He has shown absolutely that he is what he should be, an independent advisor to the government. And I congratulate him for that, because that is exactly what he should be. Can I ask him this particular question, given the clarity of his advice, as he will know that I and others have spent some time looking and working on alternative arrangements. I would like to clarify exactly what force he thinks that those would be, as he said just now, that they have an obligation to consider and or adopt such proposals if made in a reasonable way. How does that square with his paragraph 16, where he says it would be highly unlikely that the United Kingdom could take advantage of the remedies available to it if such a breach under the withdrawal agreement occurred?
Mr. Speaker, I think my right honourable friend has, by paragraph 16, wrong, if I may respectfully say. What it says was, I advised in the past that that was so. What I now consider at paragraph 17 is that the binding provisions of this joint instrument and the content of the declaration reduce the risk that we would be held involuntarily and by bad faith. Why? Because these new provisions make it easier, facilitate an effective claim to the arbitrator that that conduct is being exhibited. And those are cumulative. I say to my right honourable friend, if one has to look at the agreement as a whole, the instrument as a whole, if one puts it all together as a whole, one sees that the obligations on the Union are to treat with urgency the negotiation of alternative arrangements. There is a new obligation that has not existed before in any document that the Union has agreed, which is that it must aim to do this within 12 months of our withdrawal. Now, that is an important obligation, because it makes time of the essence. And if that deadline is passed, as any lawyer, as any the legal jurisprudence on these matters relating, for example, in domestic contexts to breach of contract, it means the parties must demonstrate that they are intensifying their efforts. And if they don't, they could be in breach of their best endeavours obligation.
Joanna Cherry.
Thank you, Mr. Speaker. Can I start by saying that I have respect and sympathy for the Attorney General. The role of the law officer is not an easy one, particularly when he or she is a party political appointment, but must nevertheless, from time to time, burst his party's political bubble in the interests of professional integrity and independence of advice. And make no mistake, that is what the Attorney General has done today. Because, Mr. Speaker, today the Emperor has no clothes. None at all, not even a codpiece. And for all the yards of flannel in paragraphs 4 to 10 of his legal opinion and in the statement today, it is quite clear, as the Shadow Attorney General said, from paragraph 19 of the legal opinion, that the legal position previously outlined by the Attorney General remains the same. So these measures fall very short of what was demanded by the Brady Amendment, and they fall very short of what was promised to the ERG, which I'm sure will not have been lost upon them or their lawyers. Because, Mr. Speaker, the withdrawal agreement has not been changed, and that the Attorney General should admit that is so is not surprising, given the weight of legal opinion about these measures overnight. Now, Mr. Speaker, I know some honourable members on the benches opposite won't take my legal opinion for it. I'm not sure why. Perhaps they think a lawyer who's a member of the SNP is not to be trusted. But at all events, I'm sure they will put some weight on the opinion of my good friend Lord Anderson of Ipswich, the former government reviewer of terrorism. And he has provided a detailed opinion overnight. I hear someone muttering from the benches opposite that he's been paid by the People's Vote campaign. But that person ought to be aware that it is the professional duty of any senior counsel to give an objective and dispassionate opinion. And perhaps the person muttering from a sedentary position shouldn't transfer their own motives to someone as honourable as Lord Anderson of Ipswich. And I'm just going to ask the Attorney General if he will agree with me and a number of the points made by Lord Anderson. First of all, Lord Anderson says the measures obtained by the Prime Minister do not allow the United Kingdom to terminate the backstop in the event that negotiations over its future relationship with the EU cannot be brought to a satisfactory conclusion. That is correct. I'm sure the Attorney General will agree. And Lord Anderson also says these measures do not provide the United Kingdom with a right to terminate the backstop at a time of its choosing, or indeed at any time, without the agreement of the EU. So Lord Anderson's right, isn't he? There's no unilateral exit here. And then Lord Anderson goes on to say that the furthest these measures go is to reiterate the possibility that the backstop might be suspended, not got out of, but suspended in extreme circumstances of bad faith on the part of the European Union, which Lord Anderson says are highly unlikely to be demonstrated. And Lord Anderson also points out that this was already apparent from the withdrawal agreement and had been acknowledged in the Attorney General's previous legal advice. So, Mr. Speaker, does the Attorney General agree with all those points put forward by Lord Anderson's independent, impartial and objective opinion? And does he agree with me that, in fact, nothing has changed, and what the Prime Minister promised has yet again, she has yet again failed to deliver?
Well, Mr. Speaker, what I think will not be lost on my honourable and right honourable friends on this side of the House, I hope, is why she is insisting and impressing upon them the facts and matters that she has just been drawing to their attention. It could be, I wonder, that there is some ulterior motive in the honourable lady's concern about the absence of a unilateral exit mechanism in all circumstances. I wonder. But may I come to the opinion of Lord Anderson, who is always worthy of the most careful attention and the greatest of respect, as anybody of his distinction should be listened to. I do say, however, that I think I would take issue with some of his comments. For example, I do think, and my opinion sets it out, and I think other lawyers are commenting to that effect this morning, that she does no justice to the fact that these measures and these improvements do mean that it will facilitate, and there is a reduction of risk, in our being able to prove and demonstrate bad faith or want of best endeavours. And she says that we couldn't terminate. There is, in fact, in my opinion, a clear pathway to termination. As she knows, what I write, in my opinion, is that if, in the circumstance where we got a declaration from the arbitral tribunal that there had been a lack of best endeavours, having regard to the accelerated pace of negotiation which this new agreement now imposes, then we could move to suspend our obligations, if we wish to do so, under the protocol. If that suspension was prolonged, we could invoke Article 20 to argue that it was no longer necessary because the inaction of the Union demonstrated that they must think that it was no longer necessary, and that could lead to termination. So it's not entirely true to say that there is no way in which these provisions could be terminated. Let me say to the Honourable Lady, suspension in these circumstances is as effective as termination. The only way in which the Union could restore that position is to come back to the negotiating table with genuinely new proposals.
Mr. Dominic Grieve.
Thank you, Mr. Speaker. I thank my right honourable and learned friend for his statement, and I have no reason to disagree with his conclusion in paragraph 19, and I commend him for standing up for his office and speaking truth to power. I do, however, have one query about paragraph 7 of his advice. In that paragraph, he describes the joint instrument as representing materially new legal obligations and commitments. But he will, of course, be familiar with Article 31(2) of the Vienna Convention, which says that such an instrument can only have legal force and be binding in the sense that the parties can't later alter or deny what they've agreed, and it's not a treaty in itself. In those circumstances, is it not the case that the breaching of the best endeavours obligation in itself does make no difference? The only difference is if there is bad faith, and that, in fact, was contained in the original agreement that we had signed.
Well, no, I don't agree with my right honourable friend, although, as ever, I listened most carefully to him. The best endeavours duty, of course, was in the withdrawal agreement originally. What this does is to firm and strengthen the context in which an allegation of best endeavours or bad faith would be made, because it sets an accelerated pace and it commits. I mean, my right honourable friend should look at it. I'm sure he will. He has. It commits the Union to specific operational commitments about how to deliver that obligation. Now, those are new agreements. They're couched in the language of agreement, and he knows, as a very distinguished lawyer, that you can't always trust the label. You have to look at the substance.
Thank you very much indeed, Mr. Speaker. Can the Attorney General confirm that in order to get to the point where the UK might be able to suspend the Northern Ireland Protocol, it would have to first persuade the arbitration panel to agree with its case, And secondly, accept that any issue of EU law arising from the case the UK had argued would have to be referred to the Court of Justice of the European Union, and that any ruling of the CJEU on that matter would be binding on the panel, on the EU, and most importantly for this discussion, the United Kingdom.
Well, of course I can confirm all those things. They're self-evident in the agreement. But may I just point out to the right honourable gentleman that though I'm sure it's a clever forensic point, the circumstance in which a point of European Union law would arise in connection with the best endeavours and bad faith clauses are difficult to envisage. The reality is it's a straightforward question of fact. Is the Union moving with the urgency, the pace, and to the procedural timetables and according to the procedural steps that this agreement now enforces? And the right honourable gentleman cannot deny. He's an honest politician. You can't look at these things in the face and say they mean nothing. These are important amplifications and clarifications of the duty of best endeavours. Now, I quite agree with the right honourable gentleman. I very much doubt whether or not we would ever get to an arbitral tribunal, because what these duties and new clarifications and amplifications do is set the framework for people's conduct within the negotiation. It's the impact upon their behaviour and conduct. Very rare is the case when one would ever get to an arbitral tribunal. What matters is the framework of obligations and responsibilities, and those have tightened, are materially tightened, on the European Union.
Indeed. Sir William Cash.
Thank you, Mr. Speaker. May I thank my right honourable and learned friend for his opinion, which is not only for the government, I would stress, but also for Parliament and for the voters. The substance of this backstop issue, to which my right honourable learned friend has just referred, is the legal and constitutional and therefore political status of Northern Ireland within the United Kingdom, which cannot be put at risk. He refers to a reduced risk of the UK being indefinitely detained in the protocol, but adds that ultimately there is no internationally lawful means, I repeat, lawful means of exit unless both the EU and the UK agree. Does he therefore appreciate on his own terms that this fundamental legal impediment trumps political considerations, and that therefore there would be insufficient protection for Northern Ireland to continue as part of the United Kingdom?
I don't agree with that. He knows that we have a difference of opinion. I hope that the honourable gentleman will move towards my position. I have still a hope that that might be so, and the reason I say that is because one has to look at the mutual incentives and disincentives for both parties to stay in the arrangement. This is a point I made in December, and for reasons I advanced in December, for reasons I advanced in my November opinion, the incentives or disincentives for the European Union are as profound, if not greater, to get us out of the backstop than to keep us in it. That's what I firmly believe. The honourable gentleman may disagree, but that's what I believe. Now, that is why I've taken the political judgment that this withdrawal agreement needs to be supported. But in saying that, these improvements do make a difference. Because, and I would say to the honourable gentleman just one other thing. In the last line of my advice, I do say no lawful exit unless a fundamental change of circumstance. And it is extremely important to remember that there is always a right to terminate a treaty unilaterally if circumstances fundamentally change. So there is no question that we have a right to exit if those circumstances apply.
Vincent Cable.
Mr. Speaker, those of us who remember some infamously politicised legal opinions, as with the Iraq War, will, I think, want to acknowledge the Attorney General's total integrity and independence. But can he explain to a non-lawyer how the respect for the international rule of law is enhanced by a unilateral declaration to break it?
No. It was to give with one hand and take with the other, the Right Honourable Gentleman. The Right Honourable Gentleman, with the greatest of diffidence and respect, is not quite right about that. The Unilateral Declaration is not incompatible with international law. It reserves the United Kingdom's right to take all measures available to it in circumstances where the talks have broken down as a result of a breach of Article 5, which is the good faith duty. So it reinforces and further stresses the right of the United Kingdom to take measures to withdraw from the arrangements if there is a breach of bad faith.
Mr. David Jones.
My Right Honourable and learned friend has noted in his opinion that the Unilateral Declaration is not an agreed document. Can he say whether efforts were made to obtain the agreement of the European Union to that declaration, and if so, why was such agreement withheld?
No unilateral declaration is worth the paper it's written on if it's objected to. My understanding, it is not objected to. It will be deposited alongside the withdrawal agreement and therefore will carry legal weight under Article 31 of the Vienna Convention.
Mr. Nigel Dodds.
Thank you, Mr. Speaker. And can I too join with others who have commended the Attorney General, and I want to pay tribute to him in terms of the dealings that he has had with us and holding entirely to his word that he would deliver a totally objective and fair legal analysis and opinion on whatever came back. So I want to pay tribute publicly as well as what I've said privately to him in that regard. Would he agree that in relation to the reduction in risk of being held in the backstop, in relation to the EU acting in bad faith or want of best endeavours, does he agree with his previous advice at paragraph 29 that all the EU would have to show good faith would be to consider the UK's proposals, even if they ultimately reject them? This could go on repeatedly without such conduct giving rise to bad faith or failure. And on the point about if it isn't a question of bad faith, but if it's just a question that the two sides can't reach agreement, he is saying in paragraph 19 that his legal opinion, the legal risk remains unchanged. We know already from the Irish government and from others what they see as the ultimate destination for Northern Ireland. The backstop is the bottom line. From what the Attorney General is saying today, provided there is no bad faith, the fact is that Northern Ireland and the rest of the United Kingdom could be trapped if it's a question that the EU does not agree with the United Kingdom to a superseding agreement.
Extremely grateful to the Right Honourable Gentleman for that question. Let me deal with it one by one. First, my opinion has changed in connection with the ability of this country to prove bad faith if it occurred. There is now a new contextual framework for judging whether the other party is using best endeavours or good faith. The time has been made of the essence, and time has been made of the essence in specific connection with the negotiating of alternative arrangements. A specific work track is set out, a specific timetable is set out. It would be unconscionable, as I say in my opinion, I forget the paragraph, but the Honourable Right Honourable Gentleman will have it, unconscionable if, having said to this country, we will set up a specific, discrete work track on alternative arrangements, which are defined in this new document as meaning facilitative techniques, technologies, and customs procedures. It would be unconscionable if, having set up a timeline for negotiating those alternative arrangements, 12 months, or we must intensify our efforts, it would be extraordinary if they never agreed to use a single one, and they refused every proposal reasonably adjusted to their core interests. It would be, I say in the written opinion, I stand by it, it would be a potential breach of best endeavours and good faith. Best endeavours is defined in this joint instrument now as requiring them to consider adverse interests and matters that are adverse to their interests. So even if these facilitative, technological and custom measures were adverse to their interests, still the duty requires them. Therefore, if there was a pattern of refusal, a systematic refusal to consider these alternative arrangements, we would have a case before the arbitration panel, and it would be a potential serious breach of good faith. I say I believe that with all candour to the honourable gentleman. He knows I wouldn't say it if I didn't mean it. It's there in my written opinion. I urge him to consider it.
Mr. Robert Neal.
Thank you, Mr. Speaker. Does my right honourable friend agree that any practical lawyer will know that legal risk can seldom be totally eliminated from any agreement of any kind, but what the parties must look at is the practical risk of that occurring? And does he not agree that what has been achieved markedly diminishes the practical risk, and that is the key consideration we need to bear in mind when looking at the broader context of what is at stake?
I entirely agree with my honourable friend. The legal ingredient in any political question must be subordinate, and in particular in connection with this political question, Mr. Speaker. The fact is that there are always legal risks of various kinds. We walk among legal risks all the time. Some of us more than others, perhaps. But the truth of the matter is we don't determine our behaviour by them. We take practical judgments every minute of the day, every day of the week, about whether the legal risks we're engaged in are ones that are worth taking. And I say to my honourable friends, as I say to all honourable members, we must come to a decision on this question today, and I would urge the House to consider carefully. There is no real legal basis to be seriously troubled that the Union will never reach agreement with us. If it's through bad faith, then we have further improvements in the deal now. But because we just can't reach agreement, when the alternative arrangements are now cemented into this deal in a manner they haven't before, I think not. In all candour, I think not.
Still a Creasy.
Thank you, Mr. Speaker. In layman and laywoman's terms, nothing has changed, but something's been added. A year to get the timescale right, and if the government can't do that, then they're going to try really, really hard for the next year. It is not possible to unilaterally stop a hard border, but it is possible single-handedly for the Attorney-General to admit that all that he's done today is amplify, not amend the original deal that Parliament voted down. To say anything else really is a matter of bad faith.
I know the honourable lady knows that I haven't attempted to say something. Of course, there's been no amending of the treaty, but what there has been is a supplementary agreement which both amplifies, extends and deepens the obligations within it. Well, the honourable member can shake her head, but really you have to look at the wording, you have to look at the text, and if I've got something wrong, she'll no doubt tell me. But the fact is there are materially new obligations here. Materially new obligations in relation to the pace and timetable, materially new obligations in relation to binding legal commitments on alternative arrangements. These set the context against which and within which those duties of bad faith and best endeavours will be measured. That is a significant difference to the deal. She's not.
Steve Baker.
Paragraph 23 of the political declaration makes it clear that we would build and improve on the single customs territory provided for in the withdrawal agreement. And we know what the European Union understands that to mean. In good faith and with best endeavours, they understand it to mean a customs union, which Dan Hannan, MEP, reminded us of earlier. So isn't it the case that if we negotiate under this agreement, we will either find ourselves trapped indefinitely in the backstop because they're acting in good faith, or we will have to agree a customs union contrary to our manifesto?
Yeah. I simply say to my honourable friend, I really don't believe so. Why not? Because the commitments that are now cemented on alternative arrangements, which require a separate negotiating track with a timetable to negotiate them, they are so now built in that, as I've said in my written opinion, it would be extraordinary if they declined to adopt any such measures. It would be extraordinary. So I don't accept that the backstop is the base for any future arrangement. But let me say another reason why it's not. Because in the political declaration, built into the political declaration is an independent free trade policy. You cannot have an independent free trade policy and have a customs union. Secondly, built into it is no free movement. Does the Labour Party support free movement? No. They speak with all sorts of voices. But the political declaration says none. You cannot belong to the single market without free movement. So I say to the honourable gentleman, these fears, I understand where they come from. But we must be bold, and we must be courageous, and we must move forward for the sake of our country.
Anna Soubry.
Mr. Speaker, can I too commend the Attorney General for his work and his efforts. I believe he's acted in all good faith, and I also pay tribute to the Prime Minister, because there is no doubt she has done her best to try to solve this problem and come back with something, but simply has not been able to, as many of us had predicted. I'm an old criminal barrister, Mr. Speaker. So, who said lock her up? Right, okay, fine. But in all seriousness, criminal barristers tend to speak in plain, simple language because we address juries. And would the attorney agree with this plain, simple assessment of the joint instrument, which indeed I have read, that it doesn't change the withdrawal agreement? It offers no new treaty or obligations at a treaty level. And could he also confirm that this is the end of the road? There are now no more negotiations with the EU, despite all the best efforts of himself and the government.
Well, I don't agree with the right honourable lady. This is an instrument which will be deposited with the withdrawal agreement, that contains material new obligations which are couched in the language of agreement. That represents an agreement between the parties, not only about the interpretation, but also about specific operational commitments. So this has a standing at equal to the withdrawal agreement. And it is in its material commitments, particularly relating to its obligations of operational character. So I don't agree with her. I think that isn't right. You have to look at the substance, not the label. Now, the right honourable lady asked me this: are negotiations at an end? Yes, they are at an end. This is the moment of decision. We now have to take the fork in the road, and we are going to have to assume our responsibilities for it.
Mr. Patterson.
Thank you, Mr. Speaker. Can I congratulate my right honourable learned friend for his work and the splendid candour of his statement and comments this morning, and also with his colleague, the DEXU Secretary, for getting alternative arrangements and an implementation date into the text. In the case, however, that despite the very best endeavours, negotiations in the very best of faith, agreement is not reached in time for the date of the end of December 2020, what can an independent, sovereign UK do if a decision is made at political level that the game is not worth the candle? Can the UK walk away?
As my right honourable friend knows, if the parties, using their best endeavours in complete sincerity of cooperation and good faith, are simply unable to agree anything, not even a few alternative arrangements, not even a partial agreement, because this, of course, can be a standalone agreement, the subsequent agreement referred to in the protocol. if in that circumstance it happens, then the United Kingdom has no unilateral exit right to leave, unless there were a fundamental change of circumstance under Article 62 of the Vienna Convention on the Law of Treaties. So my honourable friend knows that. But the question is it likely? What this deal has now done is place the burden on the Union to negotiate those alternative arrangements as a result of his work, in part. So I say to the right honourable gentleman, trust in himself, trust in the British people, trust in our ability to deliver a good deal. We can use the new contexts in this agreement, and I believe we will secure a good deal for the Northern Irish border.
Stephen Doughty.
Thank you, Mr. Speaker. Again, I thank the Attorney for his candour and sticking to that integrity in terms of the advice he's provided, and it very much does line up with Lord Anderson's advice. The backstop may accordingly endure indefinitely. Lord Anderson also says the interpretive declaration is not a clearly worded, legally binding treaty-level clause which unambiguously overrides the text. But the Attorney has repeatedly said through this that this is about politics, not law. So can he tell us, did he any point over the weekend offer the Prime Minister preliminary advice that she would not be getting what she wanted in terms of the advice for the politics of today?
I'm afraid that the honourable gentleman will forgive me for saying that I'm not permitted to, by the Law Officers Convention, say if I gave advice or what advice that would be.
This is Helen Grant.
Does the Attorney General agree with me that in law and in life it is indeed very rare for any lawyer to give 100% guarantee on how watertight a particular agreement might be, notwithstanding the fact that that lawyer may well have great confidence in that actual agreement?
I entirely agree with my honourable friend with that. The law is you're not able to put something into a test tube, put it over a Bunsen burner. If it takes green, you get the answer. The law is a question of judgment, and it's always blended, Mr. Speaker, it's always blended with political considerations, or in a commercial context with commercial considerations. And the preponderance of the two form a single judgment. It's my judgment, as the honourable lady knows, that this risk is a calculated one, but one we can now take. And I firmly believe that these new improvements make that risk more acceptable and more easy for us, this House, to make.
Caroline Lucas.
Mr. Speaker, could I press him on the status of the joint instrument? Because last night the Minister for the Cabinet Office claimed that the joint instrument had, and I quote, equal status in law to the withdrawal agreement, and that they both have the status of treaties under international law. And yet legal advice that I've seen says that the joint instrument is not incorporated into the withdrawal agreement, it is not a protocol to the withdrawal agreement, and it is not a treaty in its own right. So can he clarify whether or not the Minister for the Cabinet Office inadvertently misled the House last night?
I would need to see, if I may, what the honourable lady's quotation is in detail. But the position is that if you agree and put your name to a joint instrument of this kind, you are bound by it. You're bound by it as to its interpretation, and if it expresses agreement to specific operational commitments, as this one does, you are bound by it because it's an agreement that you will then carry out those specific commitments. It's an agreement. So we shouldn't get hung up on labels. The question is, what is its substance? It's binding.
Oliver Heald.
Right honourable friend agree with me that Article 31 of the Vienna Convention makes it perfectly clear that this protocol does have legal force, it is binding, and it is of equal status to the treaty. And does he also agree with me that there are substantial changes which have been delivered, legally binding changes, and that it's wrong to just read one paragraph of his legal advice? You have to read each paragraph of it. And when it comes to, can I just finish the point? When it comes to, I'm grateful. When it comes to paragraph, thank you very much. When it comes to paragraph 17, he makes it very clear that this is a substantial change in the level of risk.
I think I better just say I agree with that one, Mr. Speaker.
Thank you. Chris Bryant.
The attorney's argument seems to hinge on this matter of highly unlikely. But I don't know whether it's his reading of recent history. It seems to me that everything that I thought was highly unlikely 5, 6, 7 years ago has now come to pass. And shouldn't we be worrying about what may be likely over the next few years? After all, many of the governments in Europe may change. The European Commission President will certainly change. And so the highly unlikely may indeed come to pass. And I have a sneaking memory of a conversation that he and I had once in the lobby when I asked him, wouldn't it be a good idea, I think this was about 3 years ago, wouldn't it be a good idea if he should become Attorney General? And he said, oh no, that's highly unlikely.
And so it was under that particular Prime Minister, Mr. Speaker. I was telling him the complete truth as I'm telling him it now. Mr. Speaker, I think I've forgotten what the other question was, but I was so taken aback by that. That was betrayal of roping room talk, that one. I'm so taken aback by that question, I think I better sit down.
Mr. Jacob Rees-Mogg.
Mr. Speaker, my right honourable friend and learned friend has pointed out that much of what is being said is political as well as legal. Could he therefore set out for the House what penalties there might fall upon this country if a future Parliament, which obviously cannot be bound, were to decide to resile from the commitments under the backstop?
Well, my honourable friend will know that as an Attorney General, I simply couldn't give countenance to the idea that this country would break its international legal obligations. But as I've pointed out to the House, there is a right for the United Kingdom to terminate this. If fundamental circumstances change in the view of the United Kingdom, then it would attempt to resolve the matter within the Joint Committee. It would attempt to resolve it politically. But if ultimately in the sovereign right of this House and the sovereign right of the British government at the time, it took the view that those fundamental circumstances hadn't been changed, then it has an undoubted legal right to withdraw from any treaty. So let's be clear about this. These kinds of absolute interpretations of black letter text. A sovereign state has the right to withdraw if a treaty is no longer compatible with its fundamental interests or fundamental circumstances, putting it a different way, have changed. But so I would say that apart from that, of course this country could resile from its commitments. It would be unwise and it would not be in the tradition of this country to do so. And in those circumstances, it's perfectly true that the only remedies that the Union would have would be to take countermeasures, and no doubt it would pollute the atmosphere for fruitful relationships between us, which is precisely why this country will never do it, and neither would the European Union.
Kate Hoey.
Speaker, I'm not a lawyer, and millions of people watching today will not be lawyers, and I defer to the advice, obviously, of the Attorney General. But could he just tell people who are asking this question, why would the United Kingdom, a sovereign country, we signed up to the European Union, at least there was a way out of that through Article 50, although it's taken a very long time. Why would we think of signing up to anything that does not allow us to simply say, this is not working, we are not going to sign up to this, and we are leaving?
We have made a solemn pledge to the people of Ireland, both North and the Republic of Ireland, that the border will have a guarantee that it will never be a hard border. Now, that required the United Kingdom to say, in all normal circumstances, we will not depart from it. I repeat the point I make to the honourable gentleman who just asked the previous question, that in a case of fundamental change of circumstance, which it's the sovereign right of this House and the government to determine ultimately, it could withdraw pursuant to customary international law. So it's not true to say that there is not ultimately the right of this House and the government of the country at the time to exercise its discretion to do so in those circumstances. But in every other circumstance, what we were saying to the people of Northern Ireland is, we will ensure that your lives will be able to continue, as they do now at that border. I say that was an act that is worthy of this House, worthy of the government, worthy of the British people, and one that is worthy of support.
Sir Desmond Swain.
He's just said to my honourable friend, the member for North Somerset, that the United Kingdom would never do that. So why did he raise that possibility of our withdrawing from a treaty under the Vienna Convention in the first place?
No. What I said, the Right Honourable Gentleman, what I said to my honourable friend for North Somerset is that we would not do it in breach of the law. We are permitted, in a case of fundamental change of circumstances, to withdraw by the law.
Hear, hear.
We would, if such a change of circumstance came about, either because of some fundamental political change in Northern Ireland, or some fundamental change of circumstance going to the essential basis of the agreement, then we would have the right to withdraw. But in all normal circumstances, all envisageable and predictable circumstances, particularly while we're negotiating a subsequent agreement to the pace and accelerated timetable that this instrument now requires, we would not do so. And it would be wrong to do so. Wrong because it would be a breach of our obligations. Wrong because this is a law-abiding country.
Peter Kyle.
Thank you, Mr. Speaker. The Attorney General said that it is highly unlikely through the best endeavours that they cannot reach an agreement. For the last 4 months, the government has been over in Brussels trying to replace the backstop with alternative measures and has come back empty-handed. The negotiations have not delivered despite the best endeavours. Is it not the case that the very situation he describes in 2 years' time as being highly unlikely is the situation we're in right now today?
No. We haven't been attempting to secure alternative arrangements now. We've been putting forward the fact that in the future, all those alternative arrangements are likely to exist. And so the European Union has responded by saying we will set up a new special negotiating track. We will negotiate with an increased urgency and to a new timetable, and we will implement them, and they've defined them, customs, procedures and technologies and so on. So it's not right to say that the same situation arises now. These systems will be developed over time, and that is the purpose of the working group that the Union has agreed to set up with this country.
Sir Edward Lee.
May I thank the Attorney General for being so patient when I've been working on this unilateral declaration for the last 2 months, and may I thank him for including it in the final agreement. But may I ask him a detailed question, because the devil is in the detail. There is no doubt, having worked with academic opinion, that a unilateral declaration is absolutely binding as long as it is deposited at the time the treaty is ratified. And the unilateral declaration makes it clear that there's nothing to stop the UK leaving the backstop if talks break down. But it has to be a unilateral, conditional, interpretative declaration. That is what international law states, because we are only signing and agreeing to this withdrawal agreement on condition, and that's why the word conditional is important, on conditional that if the talks break down, we can exit. So can the Attorney General use now the word conditional to reassure the House?
I would need to. May I say straight away first to the Right Honourable Gentleman that I'm extremely grateful for the dialogue we've had, and I will say in no small part was the Right Honourable Gentleman the author of the seeds of this idea, because a lot of the material that he and other, if I may say so, distinguished lawyers have been able to contribute has led to the proposal that we've now adopted. But I say to the Right Honourable Gentleman, the unilateral declaration in this case doesn't need to be, say, conditional, because it is not objected to by the Union. And if it is not objected to, and it is ratified, the withdrawal agreement is ratified by the Union, it becomes binding.
Mrs. Ellen Goodman.
Mr. Speaker, I'm hoping the Attorney-General will be able to respond to me today without any reference to either his underwear or his genitalia. Last week he said, "We seek legally binding changes to the backstop that ensure it cannot be indefinite." Today he says the legal risk remains unchanged, and all he's able to offer us is a new work schedule, a sort of glorified to-do list. So if, as he keeps saying, time is of the essence, hasn't the Prime Minister wasted the last 2 months?
I'll try to obey her strictures about comments I've made before, but I say to the Honourable Lady, no, that's not quite right. I have said that the legal risk has reduced. The legal risk of being held in the backstop by bad faith or by a want of best endeavours has reduced. It has reduced because of significant improvements, which, as I said, set the context and benchmark for the enforceability of those important duties. But it is absolutely true, as she rightly says, that the risk of remaining in the backstop, absent any fundamental change of circumstance, if no bad faith or if no want of best endeavours is present, remains the same.
Dame Caroline Spellman.
I'm not a lawyer either, but the Attorney-General is doing a very good job, I think, at clarifying to me and to the House the important improvements the negotiating team has brought. And a lawyer I know characterised paragraph 19 of his letter as a minimal legal risk, unlikely to be crystallised. Would my right honourable friend agree with that opinion?
Yes, I would. I simply do not believe, given what is at stake for the people of Northern Ireland and the Republic of Ireland, and the credit and faith of the European Union, which will be on the line, and our ability now to measure their performance against the detailed timetables and procedures that are now in place, I simply do not believe that we will be unable to reach any agreement with them. Because I repeat, it's perfectly possible to approach this in stages, to agree several agreements. I mean, we will be able to agree something over the next 2 or 3 years. And the first priority, which is set out in this instrument, is the subsequent agreement replacing the backstop.
Mr. Speaker, my preference would be an arrangement that does not necessitate a backstop. But for all the words the Attorney-General has used, is it not the case that the joint instrument, the unilateral declaration, the change to the declaration, for all his words, none of those things facilitates an unconditional unilateral withdrawal by the UK from the backstop? And more than that, for all the words he has used, we are still going to end up paying a divorce bill of over £50 billion, in part in return for a political declaration that has no legal force whatsoever. That's the key point.
The right honourable gentleman is not right about that. The political declaration, under Article 184, there is a legal duty on the Union UK to negotiate a deal that is in line and according to the political declaration. That's the first point. But the second point the right honourable gentleman says is there an unconditional right to withdraw? Well, I've answered that question with respect. The only circumstance in which there would be an unconditional right to withdraw is if there was a fundamental change of circumstances pursuant to customary international law.
John Barron.
I commend my right honourable and learned friend for the way he is pursuing the remit of his office. And he is, of course, right that there is a political dimension to this decision we all have to make this evening. But can I ask him this question? He has confirmed today that if there was a fundamental change of circumstances, then this country would have the right to walk away from the agreement. Does he also, or can he also confirm that if that was to happen and we did walk away, we could take Northern Ireland with us as a member of the United Kingdom, thereby extracting them from the customs union within the EU?
Let me make it clear. The United Kingdom is the United Kingdom. It includes Northern Ireland. And there is no circumstance in which the government of this country, and certainly not a Conservative government, will ever leave Northern Ireland behind, subject to the obligations under the Belfast Agreement. So let me say, because that has been proposed, as my honourable friend knows. It's been proposed that we should have a termination right for GB only, and the Prime Minister explained why that was unacceptable.
Seema Malhotra.
Mr. Speaker, the Attorney General says that the joint instrument and the content of the unilateral declaration relating to the withdrawal agreement reduced the risk that the UK could indefinitely or involuntarily be held in the backstop in the event of bad faith. But surely that was only ever a very, very limited risk, and is it not true that the far greater risk of being held in the backstop indefinitely is not as a result of the failure of either party to act in good faith, but because of intractable differences? In such circumstances, isn't it right that the people of Northern Ireland and the Republic of Ireland should have the confidence that measures they can trust will be in place to prevent a hard border, and that the backstop would be exited on upon a new agreement being reached? Doesn't that make perfect sense?
It does make perfect sense. I have to say that I would have preferred to see a right of termination mitigated and graduated, fairly balancing and apportioning risk, and only usable in a last resort, but the Union was not willing to agree to such a reasonable and what I considered to be moderate proposal. But I agree with the Right Honourable Lady. That's why I voted for the deal. I think it is sensible that that assurance can be given. That's why the British government has given it. I would just say this, though. Bad faith and best endeavours is not now, particularly now, with the context heightened and the benchmarks tightened, is not a meaningless duty, because best endeavours requires that a party should consider proposals that are contrary to their interests, and they may have to accept them. You cannot go on refusing something that requires a reasonable adjustment in their position.
Mr. Richard Drax.
Speaker, good faith, best endeavours, trust. Can I tell my right honourable friend that that is run out? Many in this country do not trust the EU. I'm sad to say many in this country don't trust many MPs in this place to deliver what the vote told this country to do. Surely, my right honourable friend, the only option now is to get a clean break and leave on March the 29th and get our country back.
I understand my honourable friend's frustrations. I don't agree with his language. I've found that those with whom we are doing business in the European Union to be perfectly reasonable and rational people, and I have no complaint to make of the manner in which negotiations have been conducted. They've always been conducted with cordiality and civility on both sides. So I don't believe that we can't trust, because it is in the interests of the Union itself, them to reach a deal.
Tom Brake.
Mr. Speaker, had he been instructed to demonstrate it's possible to walk away from the backstop by clients at his usual generous commercial rates, would he advise them to save their money?
In what case? I'm not convinced that I fully understood the question, perhaps because I did it too much justice and thought it might be a sensible one. The truth is, I doubt I agree with
it. Indeed. And Mr. Robert Court.
Thank you, Mr. Speaker. May I place on record at the outset that whatever one may think of the issues at stake, the integrity and honesty of the Attorney General is absolutely above question, and I commend him for the approach he's taken. Much of this agreement requires a bad faith, or requires consideration of the concept of bad faith. Could the Attorney General please outline what circumstances would constitute bad faith, how the UK might prove them, bearing in mind that international arbitrators, as he will know, are loath to find that a sovereign state like the UK or a respected body like the EU have acted in bad faith? And is it not the case that if the EU were to continue to propose ideas which were in good faith but unacceptable to the UK, such as a customs union, that these proposals would not assist us?
Well, no, I don't agree. The position is more nuanced than that. A pattern of refusing to accept reasonable proposals, such as alternative arrangements, that couldn't be said to compromise fundamental interests at the border would be immediately raise a prima facie question. A pattern of consistent refusal would raise a prima facie question over the best endeavours and good faith clause. Some of these provisions are already in the joint instrument. He will have seen them. Systematic conduct, declining to consider, declining to be flexible, declining to consider adverse interests. These are real duties. They're contained in commercial contracts all the time, best endeavours duties. They're litigated, they're brought to court, as the honourable gentleman will know. So we mustn't allow our fears to run away with us. We need to trust ourselves. We can make the leverage of the backstop as powerful an argument for them not to remain in it as it is for us.
He's on his way.
Chris Leslie.
Doesn't all this hand-wringing over the backstop reflect the hubris of those who thought that they could reconcile the irreconcilable, the alchemists who believed that they could conjure up this pretense of Brexit at the same time as a frictionless, open Irish border? And haven't we finally reached the end of the road for those spinners, for those peddlers, the blaggers in the Leave campaign who stooped to lying about this all being the easiest thing in the world?
I, with respect, I don't recognize. I mean, of course, in any election, in any battle before the electorate, claims are made on both sides of the argument. I remember some pretty exaggerated ones being made on his side of the argument, to be frank. But the reality is, if there's a serious point lying beneath that stream of adjectives, I would have to say I agree with him in one respect. The enemy of the interests of this country is dangerous oversimplifications of the complexity of the problem we face. If that's the point which resides beneath his question, then I would agree. We cannot underestimate the complexity of separating ourselves from 45 years of organic, legal and other integration with the European Union. But this withdrawal agreement does not underestimate it. It addresses them at a complex level. It secures rights. It fairly apportions the dues and obligations. And it is a deal that we need in order to achieve the first stage of that separation.
Order. I'm sorry to disappoint remaining colleagues, and I'm extremely grateful to the Attorney General and to all who've participated in these exchanges. But we must now move on. Some dozens of colleagues wish to speak in the main debate, and I have to make a judgment about the importance of now proceeding. Order. Presentation of Bill, Sir Edward Davey.
Immigration Armed Forces Bill.
Second reading what day?
Friday, 22nd of March, sir.
Friday, the 22nd of March. Thank you. Order. Thank you, Geoffrey. Thanks very much indeed. Bless you. Order. 10-minute rule motion. Craig McKinley.
Speaker, that leave be given to bring in a bill to amend the Representation of the People Act 1983 to provide that election expenses relating to property, goods, services or facilities provided free of charge or at a discount are incurred only if authorised by the candidate or the candidate's election agent and for connected purposes. Mr. Speaker, legislation should be like a big red bus. There should be no ambiguity as to what it is, what it looks like and what it does. And more importantly, a full awareness of the consequences of stepping out in front of it. One such collection of legislation that currently fails the red bus test has to be election law, notably some of the provisions of the Representation of the People Act 1983. The legislation, under decades of interpretation, going back to 1868, was that the agent and candidate were the gatekeepers of election expenditure. The potential for a criminal record, custodial sentence and bar from public office makes this an equitable settlement. This was recognised under Section 90ZA in the Representation of the People Act, and I quote Section 90ZA subsection 4. For the purposes of this part of this Act, election expenses are incurred by or on behalf of a candidate at an election if they are incurred by the candidate or his election agent or by any person so authorised. All clear thus far. However, it is Section 90C that I wish to amend within this bill. This section was inserted as part of the Political Parties Elections and Referendums Act 2000. And with the continued mudslinging from all sides regarding the spending surrounding the EU referendum, I feel the red bus clarity would appear to be equally lacking in the PPRA, but that must remain a debate for another day. Section 90C introduced the wholly reasonable concept of accounting properly for goods, services and facilities provided either at a discount or free. For instance, a friendly printer in lieu of a cash donation providing below market rate or free printing. Section 90C ensured that the proper cost and corresponding donation for the discount were properly accounted for. And there was a long-established understanding of that section that the fundamental concept of proper agent or candidate authorisation still needed to apply under the authorising provision for election expenses under Section 90ZA, and I'll quote the relevant subsection. Property, goods, services or facilities is or are provided for the use or benefit of the candidate free of charge or at a discount of more than 10% of the commercial rate for the use of the property or for the provision of the goods, services or facilities, and the property, goods, services or facilities is or are made use of by or on behalf of the candidate in circumstances that such, if any expenses were to be or are actually incurred by or on behalf of the candidate in respect of that use, they would be election expenses incurred by or on behalf of the candidate. And it is B of that subsection that is of most interest, as it uses the word incurred, which mirrors entirely the word, and one must presume the intent under Section 90ZA. As part of preliminary questions to be answered prior to my criminal trial, I took the question of the proper construction of Section 90C to the appeal court after an initial interpretation of the position by the trial judge. The Lord Chief Justice at the appeal court agreed with the long understood position that I've outlined above, that for 90C to apply, proper approval of such expenditure by the agent or candidate must be there under 90ZA. And so normality seemed to have returned. But the story did not end there. The Crown Prosecution Service, with the Electoral Commission attaching themselves as an interested party, appealed the appeal court decision to the Supreme Court. That judgment was given on the 25th of July 2018, and this overturned the appeal court decision and that long-held interpretation used by all agents, candidates and political parties. And in summary, the Supreme Court, whose judgment has to stand as the definitive interpretation of Section 90C, directs that election-related expenses expended without the authorisation of an agent or candidate can nonetheless be deemed election expenses. Now, with the Electoral Commission attaching themselves as an interested party to the Supreme Court hearing, one must assume that this no need of authorisation was always their interpretation of election law. And if that were the case, why didn't they say so in their guidance for all candidates and agents for the 2015 general election? With my prosecution looming into view by the time of the snap 2017 general election, with interpretation of Section 90C at the heart of it, one might have expected the Electoral Commission, who claim the Supreme Court interpretation was always their view, to have updated their guidance accordingly. They did not for 2017. And even after the Supreme Court judgment of July 18, one might have expected that new interpretation. one that the Electoral Commission claim again to have supported throughout, to have found its way into new guidance for local elections for 2019, published just 2 months ago. It did not. But in response to my adjournment debate of 11th of February and in advance of this 10-minute rule bill today, the Commission finally published guidance with examples on this vexed question of notional spending. An undated document, but accompanied a letter to me of the 8th of March. This new guidance suggests that unauthorised expenditure becomes an election expense for reporting if there has been active engagement in the spending activity. Now, I say to members, in order that the made use of threshold is reached, it cannot be right that somebody's liberty, their reputation and livelihood can be at stake based upon 3 words and a potential prosecutor's interpretation of a candidate's knowledge or otherwise of an activity that was not authorised. The Commission offers 6 examples in their new guidance, and I'm sorry to say that it falls very short of helping. At example 5, it suggests that a national party battle bus carrying the party leader would not be a candidate spend if the candidate refuses to engage with the party leader and refuses to meet them. If the party leader says nothing more than vote Conservative or vote Labour, for instance, this would be national party spend under the PPRA. But if that party leader mentions the candidate's name whilst in the constituency, the leader might be committing a Section 75 offence. And don't forget, this is an imprisonable offence, so my right honourable friend, the Prime Minister, might want to listen to that. At example 6, if the local candidate agrees to join the party leader battle bus event and their name is mentioned, the Commission suggests that an amount of national spend must then be reported in the candidate spending return. Now, might that spending apportionment be per word, be time-based, and realistically, could that candidate have any control of what a party leader might say? Can anybody really imagine the implication to a candidate, potentially a new candidate standing within their party, of a refusal to engage with a party leader visiting their constituency? And I'm afraid these examples highlight very clearly how removed from reality the Commission is. The Electoral Commission will suggest that any change to 90C might lead to mischief if refusal to authorise would permit or encourage election-related spending to fall outside of account. There is already extensive sanction within Section 75 of the RPA 1983 that would discourage such activity, and the person spending would face criminal prosecution and would be highly unlikely to play a part in such a planned deception. So the Commission's fears are unfounded. This 10-minute rule bill brings minor changes to Section 90C to take away the ambiguity of the July 2018 Supreme Court judgment. Now, the Lord Justice's judgment has to be the right one. Their status as the highest court means it must be given the wording of the law as it stands. The question this House must now consider was whether the words previously agreed during the passage of the RPA 1983 represents the intention of Parliament and the drafters of it. I say they do not. Do members in this place ever leave a lasting legacy by their activities here? And the reason I promote this bill is to protect current colleagues across this House, colleagues and councillors yet to come and face election. And the desire to offer oneself for public service should not come with a threat to one's lip. There, and I commend the bill, sir.
Extremely grateful to the honourable gentleman. The question is that the honourable member have leave to bring in the bill. As many as other opinions say aye. Of the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
It shall be Paul Farrelly, Alex Chalk, Sir Peter Bottomley, Mr Mark Harper, Frank Field, Gareth Johnson, Mr Jonathan Lord, Jim Shannon, Anna Soubry, Bob Stewart and myself, sir.
Craig McKinley.
Okay. Election expenses. Authorisation of free or discounted support bill.
Second reading what day?
Friday, 22nd of March.
Friday the 22nd of March. Thank you. Order. We come now to the motion number 2 on business of the House today.
I beg to move.
I call the Minister to move the motion. Well, the whip has moved the motion. The question is as on the order paper. I don't think anybody wishes to speak from the opposition side. Mr. Jacob Rees-Mogg.
Mr. Speaker, I notice that this motion is in fact debatable until any hour, subject to a business of the House motion at 7 o'clock. But I can assure the House it is not my intention to speak at that length. But it is very important. We are facing before us this afternoon a motion that could determine the nation's future for a generation or more, and we are expected to do it in just under 5 hours. And I accept that every moment I speak for reduces that time, but it is nonetheless relevant to do so. This matter is of overwhelming importance to our future. It will determine the basis of our relationship with the European Union, and it may potentially have an effect on the whole basis of the United Kingdom. And it seems to me, Mr. Speaker, that 5 hours is not only not enough, but it isn't wise. And the whole process with which today's motion has been brought forth is not wise. That there is the element of bounce and there is the element of theatre. We heard yesterday that a plane was waiting on the airport fueled for the Prime Minister. This is very dramatic and it is very exciting. But it is not necessarily right for good government. What we want is to have an ability to discuss things judiciously and debate them thoroughly. And squeezing a quart into a pint pot is fundamentally unwise. But it also, Mr. Speaker, does not help the government achieve what it wishes to achieve. And that is a majority in the vote at the end of today's proceedings. Because if people feel that they have been bounced, that they have been hurried and that they have been harried, the natural instinct is not necessarily to cave in, but it is in fact to stiffen their resolve and see how the cards fall. So, Mr. Speaker, I think the government would be wise, even at this late stage, to allow an extra day for the debate, to ensure that people are not limited to 3-minute time limits at the end of the day, but can discuss this matter as fully as it deserves, and dare I say, as the nation expects, because the nation expects us to consider its future carefully. So, Mr. Speaker, although I will not seek to divide the House, I think this allocation of time motion is misguided and more time should be provided for debating something of such fundamental importance.
To the Honourable Gentleman from North East Somerset, and I note what he says about having no intention to divide the House. At least as importantly, I note for the benefit of the House that no amendment to the motion has been tabled, including by the Honourable Gentleman. The motion has been moved, motion number 2 on business of the House. The question is as on the order paper. As many as other opinions say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order. We come now to motion number 3 on section 13(1)(b) of the European Union Withdrawal Act 2018. I can inform the House that I have not selected any of the amendments. To move the motion, I call the Prime Minister.
Mr. Speaker, I beg to move. OK, you may say that, but you should hear Jean-Claude Juncker's voice as a result of our conversation. Mr. Speaker, I beg to move the motion on the order paper in my name and that of my right honourable friends. It has been 8 weeks since this House held the meaningful vote on the Brexit deal. On that day, Parliament sent a message: the deal needed to change. In response, the government has worked hard to secure an improved deal that responded to the concerns of this House. I took the concerns of this House about the backstop to the EU, sat down with President Juncker and President Tusk. I spoke to every single EU leader, some on multiple occasions, to make clear to them what needed to change. My right honourable friend, the Secretary of State for exiting the European Union, worked tirelessly with his opposite number, Michel Barnier. My right honourable friend, the Attorney General, engaged in detailed legal discussion with his counterparts in the European Commission. The result of this work is the improved Brexit deal that is before the House today. I will go on to explain in detail what has improved about the deal since January and why I believe it deserves the support of every member this evening. But first, I'll give way to them.
Isn't one of the problems the House faced in the previous session with the Attorney General that we were seeking legal answers to what were essentially political questions? And the political question that we now face is that if we don't pass this motion, we stand to lose Brexit in its entirety.
The gentleman makes a very important point. A lot of focus has been put on legal changes, and I'll come on to the fact that there are legally binding changes as a result of the discussions since the House's vote on the 29th of January. But if I'll just complete this, but the right honourable gentleman is absolutely correct. The danger for those of us who want to deliver, to have faith with the British public and deliver on their vote for Brexit, is that if this vote is not passed tonight, if this deal is not passed, then Brexit could be lost. Give way to my other friend.
Thank my honourable friend for giving way. She may have slightly lost her voice, but is it not true that were we to have a second referendum, 17.5 million people would have lost their voice?
Yes. Can I say to my honourable friend will not be surprised, given what he's heard me say from this dispatch box before, that I entirely agree with him. I believe it is absolutely imperative for this House that we meet the decision that was taken by the British people in June 2016, that we deliver on that referendum and that we deliver Brexit for the British people. And as I say, there is a danger with a failure to agree a deal that actually could end up in a situation where we have no Brexit at all. I'll give way to the honourable gentleman, and then I'll give way.
Thank the Prime Minister for giving way. Jean-Claude Juncker was very clear in his press conference, at which he was sitting alongside yesterday. This is the end of the road for negotiation. There is no further negotiation from here. Does the government completely accept that? And therefore, what happens if her motion is defeated tonight?
Can I say to the honourable gentleman, he's absolutely right. That's what Jean-Claude Juncker said in his press conference. It's what he'd made clear to me and to ministers. It's what other leaders have made clear as well. So, as I believe that tonight, members of this House are faced with a very clear choice. Vote and support this deal, in which case we leave the European Union with a deal, and I'll go on to explain why I think it's a good deal. Or risk no deal or no Brexit. These are the options. If honourable members will just bear with me, I will take a further intervention, a further couple of interventions, and then I will try to make some progress, as I'm only 2 pages into my speech at the moment. Well.
With the Prime Minister giving way, she will know that I didn't support the withdrawal agreement at the last vote, and today I will support it. Forgive me, Prime Minister. Forgive me unenthusiastically, but I will support it because I completely agree with her that there is the danger that Brexit will be lost. And it doesn't appear to be the votes in this House for no deal, but there certainly seems to be, could be the votes in this House for an extension of Article 50. None of those would deliver Brexit. They would frustrate and delay it and possibly stop it altogether. Can I say the main reason that I'm supporting the government tonight is there has been a definitive legal material change on the issue of the backstop, and that is if the European Union acts in bad faith, that the UK can permanently or on a temporary basis remove itself.
Well, my honourable friend is absolutely right. I will come on to address this point a little later in my speech, but it's very clear. We've already seen a vote in this House that has said no to no deal, and I think everybody needs to recognise, for those who want genuinely to deliver Brexit, that actually if this deal does not go through tonight, then this House risks no Brexit at all. I will give way finally in this stage to the honourable lady.
Thank you, Mr. Speaker. I'm very grateful to the Prime Minister. The Prime Minister, I think, should just spell out to this House that if we do not have a deal tonight, agreed tonight, all the arguments that we've heard, and we've listened to the Attorney General's advice about the backstop, those arguments become academic. We will not even enter into the implementation period and begin the work on the alternative arrangements to deal with the backstop if we don't get a deal. So we have to get a deal, then the implementation period, alternative arrangements during that period of time, down to Christmas of next year, before we even contemplate a backstop. Will the Prime Minister confirm we need a deal tonight?
Can I thank the honourable lady? She has set it out very clearly for the House, and I'm sure every member of this House will have heard what she has said about that. Now, I said I would make some further progress, because first I want to remind the House of the core elements of the deal on which these improvements are built. First of all, the full reciprocal protection of the rights of EU citizens in the United Kingdom, of UK citizens elsewhere in the EU, delivered by the deal. The implementation period that the honourable lady has just referred to give everyone, especially businesses, the time to adjust and to eliminate a cliff edge when we leave, that's delivered by the deal, that implementation period. The full control over taxpayers' money that comes from ending vast annual membership payments to the EU, delivered by the deal. The end of free movement and its replacement with a skills-based immigration system, delivered by the deal. The end of ECJ jurisdiction in the UK. The end of the common agricultural policy for farmers. The end of the common fisheries policy for our coastal communities. All of these are delivered by the deal. The closest possible economic relationship with our nearest neighbours outside the single market and the customs union, with our businesses able to trade freely without any tariffs, quotas or rules of origin checks. Protection for the just-in-time supply chains that provide the livelihoods of millions of families. The ability to strike our own free trade deals around the world. All delivered by the deal. The closest security partnership between the EU and any third country, so our police and security services can keep on keeping us safe in a world that contains many dangers, delivered by the deal. And by doing all of these things, the deal says and does something even more profound. It sends a message to the whole world about the sort of country the United Kingdom will be in the years and decades ahead. I will in just a moment. To our friends and allies who have long looked up to us as a beacon of pragmatism and decency, and a message to those who do not share our values and whose interests diverge from ours. It says this: the UK is a country that honours the democratic decisions taken by our people in referendums and in elections. I'll give way to the honourable gentleman.
I'm extremely grateful to the Prime Minister. Before she continues with this Britannic hyperbole, can she tell me what changes have come about to the agreement that were sought by the devolved governments in Scotland and in Wales, or were there none at all?
As the honourable gentleman knows, the devolved government in Scotland wants to ensure that we stay in the European Union. That is not a position that was taken by the British people, and I believe, as I've just said, that we should honour democratic decisions taken by the people. I'll give way to my old friend and then to my own.
Grateful to the Prime Minister. As she will recall, I voted against the withdrawal agreement in January. I'm very pleased that she and the Attorney General have been able to achieve the concessions to the withdrawal agreement. What my constituents, what my businesses want is certainty. And what they want is the certainty that the Prime Minister will not give in to the SNP's demand to a second referendum. And does she agree that this deal gives the country that certainty my businesses and constituents need?
Can I say to my honourable friend, I'm very happy to give him that certainty. As I say, I believe that we should be delivering on the vote of the British people in 2016, but I also believe it is important that we give businesses, as my honourable friend has said, the certainty for their future. And there is only one certainty if we do not pass this vote tonight, and that is that uncertainty will continue for our citizens and for our businesses. I give way to him.
May I ask the question of the Prime Minister about the unilateral declaration? And I thank her for listening, as I've been trying to make the case for it the last 2 months. But there's a question I put to the Attorney General, which I think has now been answered. The unilateral declaration, am I right in saying, states that there is nothing to stop the United Kingdom leaving the backstop if talks break down? That is a very clear unilateral statement. If talks break down, it doesn't have to prove, am I right in saying this, that the EU has to prove good faith? It is a unilateral declaration. And we do not have to use the words conditional because the EU has not objected. And if we lay this declaration at the time of ratification, it is binding on the EU.
Can I say to my honourable friend, one of the key elements that, in relation to what he has said, is that this unilateral declaration has not been objected to by the European Union. That is what ensures its legal status and its legal basis. And as he says, what we say in there is that in the circumstances in which it is not possible to arrange the future relationship with the European Union, then the United Kingdom is recording its understanding that nothing in the withdrawal agreement would prevent it from instigating measures that could ultimately lead to disapplication of obligations in relation to the protocol. Now, I will make some further progress before I give way again, because this is a country, we are a country, where passionately held views do not stop us from making compromises to achieve progress. We're a country that values both our national sovereignty and the unbreakable bonds of a shared history and an independent future that connect us to our friends and neighbours. A bad deal would be even worse than no deal, but best of all is a good deal, and this is a good deal. Mr. Speaker, members acknowledged many of the benefits delivered by the deal, but nonetheless rejected it in January. So let me now set out what we've added to the deal on the table since the last vote. On the rights of EU citizens, we've waived the application fee so that there's now no financial barrier for any EU nationals who wish to stay. As I've said before, they are our friends, our neighbours, our colleagues. They've added much to our country and we want them to stay. On the rights of workers and on environmental protections, assurances about the government's firm intentions were not enough. So we have committed to protecting those rights and standards in law. And if the EU expands workers' rights, we will debate those measures here in this Parliament, and that this House will vote on if we want to follow suit. In just a moment, this Parliament has already set world-leading standards, and after we leave the EU, we will continue to do so. I give way to the Honourable Lady.
The Right Honourable Lady for giving way, and I hope that her voice lasts out to the end of the speech. The DUP have just announced that they're not supporting her deal. Her own ERG have announced that they're not happy with the deal. Doesn't she now think that she should have reached out across party from the beginning to seek a proper consensus across this country to give us a chance of moving forwards? And will she now admit that her strategy has comprehensively failed?
To the Honourable Lady, that there have been alternative approaches to the deal that is on the table that have been proposed. They were proposed the other week by the Leader of the Opposition. That was comprehensively rejected by this House. There has been no... We have continued to work with members across this House and continue to work with members across this chamber to understand the issues that need to be addressed. And what we have done on workers' rights is one example of exactly that work. I know I'm going to make some progress. I know that for many members on this side of the House, and also for the DUP, the biggest concern was about a more difficult issue which defies simple solution, the Northern Ireland backstop. It is a complex issue that reflects the complex history of these islands and the long and difficult road that successive generations of British and Irish people have walked down to reach the peace and stability that we have known for the last 20 years. I've talked in detail about the backstop many times in speeches and statements in this House and in Northern Ireland. I've explained why an insurance policy to guarantee no hard border between Ireland and Northern Ireland is necessary. I know that there are a number of concerns about how it might operate, none greater than the fear that the EU might seek to trap us in it indefinitely. Along with the Attorney General and the Brexit Secretary, I fought hard and explored every idea and avenue to address these concerns, including a time limit, a unilateral exit mechanism, or the replacement of the backstop with alternative arrangements. Just in a minute, but the House knows how complex negotiations work, and ultimately you have to practice the art of the possible. And I'm certain that we've secured the very best changes which were available. And as the Honourable Lady made clear earlier, it has been absolutely clear that this is the deal. I give way to the Honourable Gentleman.
I thank the Prime Minister for giving way, and she knows why I won't be voting for the deal tonight, because it will make my constituents poorer and less safe. But on this specific issue of the legal advice from the Attorney General over this complex issue of the Northern Ireland backstop, could she confirm whether she was given preliminary advice on Saturday or Sunday that he was unlikely to be able to change his advice in perhaps the way that the Prime Minister wished him to?
Can I say to the Honourable Gentleman that obviously the Attorney General has been involved in the discussions that we've been having with the European Union, but at the end of the day it is up to him to make his legal opinion and to give his legal advice to this House, which is exactly what he has done.
Thank my right friend for giving way. I believe she just said this is the deal. Is it not the case that if Parliament votes against this deal and then in the forthcoming days were to vote for an extension, wouldn't that not only be incredibly bad for businesses who desperately want an end to this uncertainty, but also risk putting the ball into the EU's court for determining the terms of that extension?
My honourable friend is absolutely right. First of all that would do is extend uncertainty. But secondly, it is not a guarantee that any extension would be agreed by the European Union, or that they would agree an extension in the terms in which the United Kingdom asked for it. Because an extension has to be agreed by all of the parties, and that includes the 27 members of the European Union. I'll give way to the Honourable Gentleman.
Sir, and I'll give her a moment maybe to get another cough sweep from the Chancellor as well. It's clear, and you can see from the benches here, it's clear that the Prime Minister is going to lose tonight and to lose badly, which will drag this place and also jobs and businesses over the edge with that threat of a no deal. It's a responsible thing to do now, not to seek that extension so that we can get some kind of way out of this calamity.
Minister! The way out of the situation we're in is to have faith with the British people and vote for the deal this evening that gives them what they voted for in the referendum. I will give way to
I thank the Prime Minister for giving way. As she knows, many of us would have preferred a circumstance where we could unilaterally have withdrawn from this agreement, and that does not apply after what the Attorney General said earlier. That means we're going to a circumstance where there will be a deal of trust with respect to how we resolve the backstop, and in particular over the issue of whether the alternative arrangements prove acceptable to the European Union and the Republic of Ireland. Some of those alternative arrangements are ones that have previously been rejected by the Union and the Republic of Ireland. Can she tell the House whether she detected any change in mood on the part of the Union and the Republic with respect to a constructive outcome to the dealing with the Northern Ireland border?
Yes, can I say to my honourable friend, I think what has been obvious is a change in willingness from the European Union to be actively working on those alternative arrangements. As he's heard me say before, it was not possible to complete that work in time for the timetable we currently have, pre the 29th of March. But the firm commitments that have been given in the documents that we have negotiated now with the European Union show that willingness on their side to be actively working with us to find those alternative arrangements and to define them in a way that it means that the backstop can indeed be replaced. Now, I'm going to make some progress. Because there are three elements to the improved deal on the backstop, and I want to go through all of those. The first is a joint instrument, not a further exchange of letters, but something with comparable legal weight to the withdrawal agreement. It provides a new, concrete, legally binding commitment that the EU cannot act with the intent of applying the backstop indefinitely. Doing so would breach the EU's obligations under the withdrawal agreement and could be challenged through arbitration. Were the EU to be found in breach, the UK could ultimately choose to suspend the backstop altogether, with that suspension lasting unless and until the EU came into compliance with international law. In these circumstances, we could also take proportionate measures to suspend the payments of the financial settlement. Just as important, the joint instrument gives a legal commitment that whatever replaces the backstop does not need to replicate it, providing it meets the underlying objectives of no hard border between Northern Ireland and Ireland. I give way to the Honourable Gentleman.
The Honourable Lady for giving way. She's talking about the EU suspending, and she's talked earlier about bad faith and the UK being a beacon across the world and it sticks to its deals, she said. But can she remind them, and particularly in Europe they wanted to remember this point, that when 28 countries went to Salzburg in November and made a deal and struck a deal, who then later ratted on the deal, leaving the 27 high and dry? Was it her government?
Prime Minister.
Can I say to the honourable gentleman, first of all, his history is a little wrong, because actually the agreement on the withdrawal agreement and the political declaration of the future framework were not agreed in Salzburg. They were agreed later last year in November in Brussels. And secondly, he says, who was it who went back on the deal? Was it the government? No, the government voted for the deal. He voted against it. So on that point, if he wants to look for an example of bad faith, look in the mirror. Now, some colleagues, I'll give way to the Select Committee Chairman.
Very grateful to the Prime Minister for giving way. She referred a moment ago to the possibility of the UK suspending the operation of the Northern Ireland Protocol. In his legal advice published today, the Attorney General talks also about measures to disapply the provisions of the protocol. Can she tell the House whether suspension, which has to be temporary under the withdrawal agreement, and disapplication are one and the same thing, or are they different?
Prime Minister. Thing, but also, can I say to the right honourable gentleman that in fact, if you look at the arrangements that are in the withdrawal agreement and as supported by the new instruments that we have negotiated, it is the case that if suspension takes place over a period of time, such that it is then obviously obvious that the arrangements were no longer necessary, they wouldn't have been in place, and everything would have been operating without those arrangements, then actually a termination of those arrangements is possible within the arrangements here. Now, some colleagues were concerned that the political declaration says that the future relationship, I'll just make a little for more progress, the political declaration says that the future relationship will build and improve on these arrangements. We now have a binding commitment that whatever replaces the backstop does not have to replicate them. The instrument also contains commitments on how the UK and EU intend to deliver the alternative arrangements. Immediately after the ratification of the withdrawal agreement, we will establish a specific negotiating track on alternative arrangements to agree them before the end of December 2020. The instrument also entrenches in legally binding form the commitments made in January's exchange of letters between Presidents Tusk and Juncker and myself. These include, and I'll just cover this point, these include the specific meaning of best endeavours, the need for negotiations to be taken forward urgently, the ability to provisionally apply any agreement, which reduces the risk of us ever going into the backstop, and a confirmation of the assurances made to the people of Northern Ireland. I'll give way to the Honourable Lady first, and then you.
I'm very grateful to the Prime Minister for giving way. I was puzzled by her claim that the joint instrument is of comparable legal weight to the withdrawal agreement. I'm sure she'll be aware, as a matter of international law, the withdrawal agreement is a treaty. The joint instrument is not a treaty. It's merely what's known as a document of reference that can be used to interpret the withdrawal agreement. So would she care to rephrase her assertion that the joint instrument is of comparable legal weight to the withdrawal agreement, because it's simply wrong as a matter of law?
Exactly.
Prime Minister.
I say to the Honourable Lady that obviously The withdrawal agreement is an international treaty. This is a joint instrument which sits alongside that international treaty, which does have the same standing in that in any consideration that is given to any aspect of that withdrawal agreement, this will be part of that consideration. So it is, the effect is the same, as I indicated earlier. I said I would give way to the Honourable Lady.
It does need to be said that most of us, when we're unwell, can take to our beds, but it is absolutely noticed by everybody in this House that this Prime Minister just simply battles on, and it's appreciated. Having said that, I fear this is too little, too late. The Prime Minister talked about compromise. Would she agree and confirm that some 2 years ago, I and others who sit behind her told her that there was a majority, a compromise across this House for the single market and the customs union that would have delivered on the referendum, secured the problem with the border and done the right thing for business? Would she confirm that she rejected all of that and the difficulty has been her inability to move away from her red lines?
Prime Minister.
To the Honourable Lady, Right Honourable Lady. The point is we have to look at what it was that the British people were voting for when they voted in the referendum in 2016. We also have to look on the manifesto that at the time of the last general election she and I both stood on, which was very clear in relation to those matters in the customs union and the single market. What we've put forward are proposals which enjoy benefits of some of the benefits of a customs union, like no tariffs, no rules of origin checks, but do it in a way that delivers an independent trade policy. That's what people want to see, and that's what we will be delivering. I will just make a little more progress before I take any more interventions. I have been quite generous already in interventions. I wanted to say a word about Gibraltar. On Gibraltar, these documents confirm the understanding reached between the UK and the EU on the interpretation of Article 184 of the withdrawal agreement as regards territorial scope of the future relationship. We will always stand behind British sovereignty for Gibraltar, and the UK government negotiates for the whole UK family, including Gibraltar. The second element that we've negotiated is a UK-EU joint statement in relation to the political declaration. I will give way in a few moments, just make a little more progress. The political declaration, this second element, the statement in relation to the political declaration, sets out a number of commitments to enhance and speed up the process of negotiating and bringing into force the future relationship. There is a new commitment that the negotiating track on alternative arrangements will consider not only existing facilitations and technologies, but also those emerging. Third, I'll give way to the Honourable Lady and then.
I thank the Prime Minister for giving way on that point, and she did say earlier that she thought there'd been a change in attitude about looking at different ways of dealing with the Northern Ireland-Irish border. Would she agree with me that if the Irish Taoiseach did what the previous Irish Taoiseach did, which was allow the civil servants to meet with our civil servants, that if there really was goodwill and intention, that the Taoiseach would now say that their civil servants should start the process now and not wait until we've gone much further along the line?
Minister.
Can I simply say to the Right Honourable Lady that we are happy at any stage to sit down with the Irish Government and to talk to them about the arrangements that could be in place in relation to the Northern Ireland border with Ireland.
On Gibraltar, can she confirm that well over 90% of the people of Gibraltar voted to remain in the European Union, and that if her deal goes down tonight, it will be essential that Gibraltar continues to have a relationship as close as possible with the European Union single market?
What can I say? He was right about his facts in terms of the vote. And of course, significantly, the last time the people of Gibraltar were asked whether they wanted to continue their relationship with the United Kingdom, they were very clear, overwhelmingly, that that was what they wanted. That's why we are clear that we negotiate on behalf of our whole UK family. What the deal that is on the table tonight, the deal that people will be voting for, delivers the close relationship for the future that the Honourable Gentleman has been talking about. What it does is it delivers on the result of the referendum, but it also recognises the importance of a close relationship for us for the future with the European Union. I'm now going to make some further progress. Third, alongside the joint instrument on the withdrawal agreement, the United Kingdom government will make a unilateral declaration relating to the temporary nature of the backstop. Such declarations are commonly used by states alongside the ratification of treaties. The declaration clarifies what the UK could do if it was not possible to conclude an agreement which superseded the protocol because the EU had acted contrary to its obligations. In these circumstances, the UK's understanding is that nothing in the withdrawal agreement would prevent us from instigating measures that could ultimately lead to the disapplication of our obligations under the protocol. Were we to take such measures, the UK would remain in full compliance with its obligations under the Belfast Good Friday Agreement and to avoid a hard border on the island of Ireland. I'll give way to the honourable lady.
I'm very grateful to the Prime Minister for giving way, and I really do want to know why the Prime Minister has consistently sought to get a deal that satisfies hardliners on her own side, rather than reaching out across the chamber to get an agreement that would be a softer Brexit, but it would protect the Good Friday Agreement in Northern Ireland more than her current deal does.
Can I say to the Minister? First of all, if she thought I was placating everybody on my side of the House, I don't think the vote would have been rejected in the first place. So I think she's rather wrong on that. Secondly, I did reach out to the front bench of the opposition of her party. I had a meeting with the Leader of the Opposition. There was one meeting between the Chancellor of the Duchy of Lancaster and the Shadow Secretary of State. We offered other meetings, and voice came there back none. So that's I'll make some further progress. Mr. Speaker, there are considerable improvements on the deal that the House considered 8 weeks ago. In particular, there were 3 key issues raised by my honourable friend, the member for Altrincham and Sale West. On the question of giving legal status to the assurances on the backstop, the joint instrument is a legally binding text at the same level as the withdrawal agreement, namely a treaty-level instrument. On alternative arrangements, we have an agreement that they will replace the backstop, and this commitment is in the legal instrument, not just the political declaration. And on the question of an end date, the core concern of colleagues was that we should not be trapped indefinitely in the backstop. The Attorney-General has today changed his legal analysis to note that this risk has been reduced, and that if the EU were to act in bad faith, short of their best endeavours, the backstop could be suspended or even terminated. And that this is a materially new legal commitment.
Grateful to her for giving way. The Prime Minister's whole strategy this week is depending on expecting that MPs will change their minds in a matter of weeks between votes, at the same time as she won't allow for the fact that the public might have changed their minds in the space of many years, 3 years now. So will she accept that the best chance she has of getting her deal through Parliament would be to make it subject to a confirmatory vote of the public as a result?
Prime Minister.
Can I say to the honourable lady, as I've said on many occasions before and as I've indicated earlier in my speech, I profoundly believe that when the Parliament of this country says to the British people that the choice as to whether to join, to remain or to leave the European Union is theirs, that, and when the government of the day, well, I say to the honourable lady, she says, well, they've changed their minds. There isn't actually evidence that the British people have changed their minds on this. There isn't evidence that the British people have changed their minds. And where would it end? So what? So you have another referendum, and there's a different result, and then everybody says, well, let's actually have a third one. Or there's another referendum, and there's the same result, and the honourable lady would probably still stand up and say she wanted a third referendum to try to overturn the decision. I'll give that.
I'm grateful to the Prime Minister for giving way. The simple fact is that people in my constituency and others who voted leave did so with a promise and expectation of something better. Does she not agree that what we are facing this evening is a choice of voting for a deal that she knows, and I know, this House knows, and I suspect the majority of the people in the country know, that whether it's on economic cooperation or security cooperation, leaves our country demonstrably worse off? Why on earth is she asking us to countenance that?
The honourable gentleman, he said he talked about those in his constituency who voted leave. What is absolutely clear from the analysis that the government published is that if we are going to honour the result of the referendum, and I believe we should, and I'm sure his Leave voters want us to do that, the best deal to deliver for the British people in honouring that referendum is the deal that the government put forward back in the summer. And this deal and this deal that is here tonight is the deal that actually gets us onto the point of negotiating that future relationship in the interests of constituents of everybody sitting across this House. Now, I am going to make some more progress. I know that some honourable and right honourable members will still have concerns about the backstop, but real progress has been made, and all of us should put out of our minds the idea that going round this again will get us any further forward. Responsible politics is about pragmatism, about balancing risk and reward. So members across the House should ask themselves whether they want to make the perfect the enemy of the good. Mr. Speaker, given Northern Ireland's unique position and the fact that it will be the only part... Oh, sorry, I did say I would give way to my honourable friend.
I thank my right honourable friend for giving way, and most of us in this place commend her and her team for their stamina in these negotiations. We accept there is a political dimension, but could you just clarify one point for those of us who are concerned about the indefinite nature of the backstop, and that is this. In future, this country could unilaterally decide to walk away from the agreement if there was a fundamental change in circumstances, and we could do that as a United Kingdom, including Northern Ireland, even if that meant Northern Ireland leaving the customs union within the EU.
Prime Minister.
I think this was a point that the Attorney General responded to in his statement earlier, which is that, of course, it is open to any sovereign government to choose to take a decision to disapply something into which it has entered into. Of course, that would have consequences, and I think I'm right in saying my right honourable friend and learned friend indicated that that was not a route that he could recommend ministers to take. But of course, my honourable friend is right that that is always open to a sovereign government to act in that way.
Will the Prime Minister give way?
I'll give way.
I'm very grateful for the Prime Minister giving way. Could the Prime Minister confirm the element of risk of going into the backstop when this country was told that this would be the easiest trade deal in history?
Well, can I say to my honourable friend that, of course, any negotiation between different parties of this sort does take time. Trade deals do take time, often a shorter time than many people think, and we have yet to negotiate the trade deal for the future, which we'll be doing when we get this withdrawal agreement deal through. Now, I'm just going to continue because I want to make a very specific point about Northern Ireland, given its unique position, and the fact that it will be the only part of the UK to share a border with the EU. And I want to set out further commitments today on protections for Northern Ireland and its integral place in the United Kingdom. First, the government will legislate to give a restored Northern Ireland Assembly a vote on a cross-community basis on whether the backstop should be brought into force if there are delays in the trade talks. If Stormont does not support this, then ministers will be bound to seek an approach which would achieve cross-community support. This could, for example, be an extension of the implementation period. It has previously been the case that the understanding was that the choice would be between the backstop and the implementation period. The introduction of alternative arrangements, of course, brings another element into that. But there is that key commitment in relation to the Northern Ireland Assembly. If Stormont does not support this, then if Stormont were to support an implementation period as the alternative, ministers would be bound to seek an extension of the implementation period, assuming that that had achieved cross-community support. Secondly, we will maintain the same regulatory standards across the United Kingdom for as long as the backstop is in force. This is a commitment we have already made, but I can now tell the House that we will legislate to make this legally binding. And thirdly, the government will legislate to prohibit any expansion of North-South cooperation through the withdrawal agreement. That will remain a matter for the Northern Ireland Executive and Assembly, in line with the Belfast Agreement. In just a moment, I'll just make this further point. At every stage of these negotiations, my determination has been to deliver a deal that works for every part of the United Kingdom, and that includes Northern Ireland. I'll give way to the Honourable Lady.
The Prime Minister has talked a lot about concerns around the backstop, but for many honourable members, the biggest concern is her withdrawal agreement provides no legal certainty about any of the fundamental questions about our future relationship with the EU. As a result, we will be back here time and time again, and that far from providing certainty for the future, her blindfold Brexit is the most uncertain future for our country of all.
Prime Minister. It's a very simple and basic point that the Honourable Lady seems to have forgotten. It is not possible for the European Union to negotiate and sign the legal text of that future trade relationship with the United Kingdom while we are a member of the European Union. We cannot do that until we have left the European Union. So, if the Honourable Lady wants us to get on to negotiating the future relationship, vote for the deal tonight. Let's get on to that next stage. Now, important though the backstop is, it was not the only concern honourable members had. Another was in regards to the political declaration. Because it provides, as the Honourable Lady has hinted at in her question, it provides for a spectrum of possible outcomes. Members asked how they could be confident about what sort of future relationship the government would negotiate. Can I just continue to make my point? I'm sure we can all learn lessons from how we approach this first phase of the negotiations as we move on to the second. For my part, I've no doubt that the government does need to build a strong consensus in the House before we go on to negotiate the future relationship, not least to ensure the process of ratification is smoother than that for the withdrawal agreement. And that's why we've committed to give a much stronger and clearer role for this House and for the other place during the next phase. Not just a consensus in Parliament either. Businesses, trade unions and civil society must all play a much bigger part, contributing their expertise in a collective national effort to secure the very best future relationship with the EU. That new approach, that new approach will start with the withdrawal agreement bill. If the deal passes tonight, notice of presentation will be given tomorrow and the bill will be introduced on Thursday. And as we discuss that bill, we can debate how exactly we will ensure that this Parliament has the full say it deserves. Mr. Speaker, I'll give way.
Can I thank the Prime Minister for giving way? Given the clock is ticking, there are millions of people working in businesses up and down this country that want the most certain outcome, and voting for this deal today is the best way of delivering it. Voting the deal down will lead to more uncertainty, and none of us know where we're going to end up. So I, for one, will be supporting the government of the Prime Minister.
Can I thank my honourable friend? He has made a very important point. Rejecting this deal tonight, the only certain thing about rejecting this deal tonight is that it increases uncertainty. Businesses and individuals want certainty.
And I do feel for my right honourable friend with the throat condition she's got at the moment, I really do. But having said that, she's referred to the fact that the backstop is very important. We all know that, and rightly so. The question, however, is also under this withdrawal agreement and the withdrawal implementation bill which is to come. First of all, we haven't seen a draft of it, and hoping we can get that very soon, as my European Scrutiny Committee have just said in the report. But the second thing is that in there it is quite clear that we will not be discharging what she said herself at Lancaster House. We would not truly leave the European Union unless we regain control of our own laws. Under Article 4, it's clear that that is not the case. What is the answer of my honourable friend to that point?
Prime Minister. To my honourable friend, first of all, I'm pleased to hear that he's keen to see the withdrawal agreement bill. That bill, of course, as I've said, will be presented to this House this week if my honourable friend and others vote for this deal tonight to get this deal through. If my right honourable learned friend. But I also say to my honourable friend, yes, there are provisions in relation to the role of the European Court of Justice during the period for our winding down and winding our way out of the European Union. But it is clear, and that covers the implementation period. What is absolutely clear is once we are beyond that point, there is no jurisdiction of the European Court of Justice other than for a limited period of years in relation to citizens' rights. There is no jurisdiction of the European Court of Justice in this country. I give way to the floor.
She just said that if she manages to get her withdrawal agreement approved by this House, she doesn't want the next stage of serious negotiations about our long-term future to proceed in the same way, and she's giving a greater role to Parliament. I strongly endorse that. We can't have another arrangement where she just reaches a perfectly satisfactory agreement on the 3 points she did, and then we descend into parliamentary farce as different people argue about what changes they like. So isn't the best way of proceeding, if she gets her withdrawal agreement through, then to have some indicative votes in the House of Commons before the serious negotiations start, so the government can go into those negotiations knowing what a broad mass of Parliament is likely to support and back her up if she can achieve it.
Can I thank my learned friend for the point that he's made? Actually, I think there are a number of ways in which we can ascertain what the views of the House would be prior to entering into the next stage of negotiations. And obviously, we have been looking at the details of that and will want to be consulting and talking across the House in relation to that matter. But of course, the first step, as my right honourable and learned friend rightly indicated, in order to get onto that stage, is to pass the deal tonight. Mr. Speaker, no, I really am going to try and make a little more progress. I have been extremely generous with interventions. Not everybody in this House is as generous as I am when it comes to interventions. Mr. Speaker, I set out to the House 2 weeks ago the specifics of what will happen if the deal is rejected tonight. We will first of all return tomorrow to consider whether the House supports leaving the European Union on the 29th of March without a withdrawal agreement and a framework for a future relationship. If the House votes against no deal, it would vote on whether or not to seek an extension of Article 50. I sincerely hope that the House will not put itself in this invidious position. We can avoid it by supporting what I profoundly believe is a good deal and a substantially better deal than we had 8 weeks ago. But if it comes to it, the choices would be bleak. In the long term, we could ultimately make a success of no deal, but there would be significant economic shock in the short term, and be in no doubt about the impact that would have on businesses and families. We would lose the security cooperation that helps keep us safe from crime, terrorism and other threats, and we would risk weakening support for our union. I note that the Right Honourable Member for Ross, Skye and Lochaber had tabled an amendment seeking a second Scottish independence referendum. Polling shows that support for both Scottish independence and United Ireland would be higher if we leave without a deal. While a no deal in the absence of institutions in Northern Ireland would create a substantial problem of governance there. Should the House reject leaving on the 29th of March without a deal, and then support the government seeking an extension to Article 50, our problems would not be solved. An extension without a plan would prolong the uncertainty, threatening jobs and investment. Yet even as it did so, it would not change the debate or the questions that need to be settled. It would merely pass control to the European Union. They would decide how long an extension to offer, meaning we may not get what we ask for. They could even impose conditions on an extension. That could mean moving to a Brexit that does not meet the expectations of those who voted to leave. Or even moving to a second referendum with all the damage that that would do to trust in our democracy. Equally, there is a risk that having voted for an extension, this House would still not be able to agree a way forward, and we would end up leaving without a deal. And just one moment, I'll give way to the Honourable Gentleman. If any of these things were to happen, it would be no good blaming the European Union. Responsibility would lie with this House. Our failure to come together in the national interest to deliver on the vote of the British people. I will give way to the Honourable Gentleman and then the Honourable Gentleman.
Yes, I'm extremely grateful for her giving way. The first of her Brexit secretaries is sitting in his place.